Paul.
Okay, great. Recording to the cloud and webcasting to YouTube, Madam Chair. Anytime is your call.
Okay. Thank you. Good morning. The hearing board of the South Coast Air Quality Management District is in session. Today is January 7th, 2021. The time is 9:00 a.m. and we are meeting remotely via Zoom due to the current pandemic and the stay-at-home orders in the state of California. Hopefully I fixed my sound and everyone can hear me today. And if not, just let me know during the hearing. We have one matter on the calendar today, and that is coast plating, case number 6201-1 for an emergency variance. And who is representing coast plating today?
Hello, this is Adam Alonso. I'm the EHS manager at Coast Plating.
And you will be representing coast plating today?
Yes, that's correct.
Okay. And can you just spell your last name for the record today?
I mean, our legal counsel is Albert Cohen. Is that what you meant by representing? Sorry, this is my first time.
That's okay. That's what I meant.
Okay. Sorry about that.
Who is the attorney representing and who will be conducting the questioning of witnesses, etc.?
Albert Cohen.
Mr. Cohen, we cannot hear you.
Can you hear me now?
Not very well.
No, I could hear you when you first logged on this morning, Mr. Cohen, remember? Did
Yes.
you do anything different with your settings?
Oh, I didn't change anything.
Right, I did, and I did hear you before when you were answering the question of why we started with Exhibit 3.
I don't know what to say. Can you hear me now? If I get closer, does that help?
Maybe if you speak up very loudly, because we can hear you, but it's still pretty low.
Madam Chair,
Yes.
yesterday you indicated with your computer, there's a setting in Zoom. Maybe that would help. I don't remember exactly.
Yes.
That.
Oops. If you look at these, if you hover your mouse and you look on the bottom left where you have the stop video icon, there's a little caret pointing up. If you press on that, it allows you to go into video settings. And in there, you can look at your audio settings. And when you look at your audio settings, there's something that generally gets pressed automatically, which says automatically adjust microphone volume. You don't want that pressed if it is. That was my issue.
Okay, does it work now? I unclicked it.
Still very low. Perhaps,
Really?
I don't know, Paul, would it make sense for him to leave, if it was working before, to leave and come back?
I know this sounds silly, but there's no papers or materials blocking your microphone pathway.
No, there isn't.
Is it a laptop or a desktop you're using, sir?
Well, it's a laptop, but I have a separate camera.
Okay, now that was a little better there. It's almost seems like something's in the way or you're speaking closer to the microphone itself. That's what it seems like.
All right, I will try to get as close as I can. What else to do? That's why I got on early, because I wanted to make sure we were okay with this. And it says on my microphone, it says the volume is fine.
It does sound quite muffled.
Right.
Is that any better?
Yes.
Okay. Sorry.
Whatever you did that worked well. Okay, so can you just state and spell your name and tell us who you are representing Coast Plating today?
Yes, Albert, A-L-B-E-R-T, Cohen, C-O-H-E-N. and I'm with law firm Loeb and Loeb. That's LOEB ampersand LOEB.
Thank you. And who is representing the executive officer today for the district?
Sherry Hani-Zavara on behalf of the executive officer.
Thank you, Ms. Hanizava. Okay, first thing I want to ask. I see that you're asking for an emergency variance to last through the 30th of January. Is that correct? I was gonna ask, knowing that you were having the test done today, I didn't know if you realized that the hearing board cannot grant retroactive relief. So I know you've asked for the relief to begin in December, but the hearing board cannot do that. It would have to start from today and move forward. Okay. All right, before we begin, a few things. First of all, because this is an emergency variance request, and because there has been no notice to the public of today's hearing, the board will have to bifurcate the hearing today so that we can establish whether there is good cause to proceed in absence of notice to the public. And Mr. Cohen, are you familiar with the findings for good cause? I can share them on my screen if not.
Yeah.
Yes. Okay. So we will dedicate the first portion of the proceeding to determining whether there is good cause, and in particular, whether there was diligence in filing, whether the violation could have been avoided, or the circumstances leading to the violation could have been avoided, and that denial of an emergency variance today would result in an unreasonable or unavoidable adverse impact to petitioner. So that's what we will focus on. Should we enter the documents that we have, at least mark them? Why don't we do that? We have a number of documents that we have received. We received the petition. We don't have to mark the petition. We have attachments to the petition, but I'm trying to figure out a way so that we can start with the exhibit number 3 that we have, and not have to remark everything, because that will be very confusing.
I mean, can you mark this exhibit?
You know, Mr. Cohen, we're not hearing you very well again. I'm not sure what you did that first time that fixed the problem. Not sure why I'm missing document. Okay. We have attached, why don't we do this? Attached to the petition is a diagram, a process flow diagram for chromic anodizing operations. We can mark that as exhibit 1. And then the rest of the attachments are permit and rule provisions from which a variance is requested. We can mark that, all of those together, the rule 203 and 1469, as well as the permit conditions as exhibit 2. And then we can mark the exhibits 3 through 10 as they are marked, right, through 10. And then we'll mark, so those exhibits as they appear will be 3 through 10. And then exhibit 11 will be the supplemental filing in support of Coast Plating's petition for variance. Okay, and did you follow that, Madam Clerk? Okay, so this will be exhibit 11, which is the supplemental filing in support of Coast Plating's petition for variance. All right. We don't have to mark, I don't believe, but we did receive as part of the transmittal. I think we should mark it. Why don't we mark that? We have the transmittal from the ex parte emergency variance, which was denied. We have the transmittal of the response of the district, which had included a written opposition and a declaration of Frederick Chung. We're going to mark that as Exhibit A, as an apple for the district. I think that's all of the outstanding documents that should be marked at this time. And why don't we swear in witnesses? So anyone who is present today, who either plans or who may give testimony today in either part of today's hearing, please raise your right hand to be sworn in. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you very much. I think I am going to share the screen while we take opening on good cause, so that we can all be on the same page as to the findings that the hearing board looks at. So let me do that.
By the way, can you hear me now? Is that any better? No.
No. Maybe I can't. Sorry, I was going to share my screen. However, I'm having an issue. But first, I think we could. Oh, there we go. We need to make sure that Mr. Cohen is heard. So, Mr. Cohen, if we can't fix it, I think the best course would be for you to try again, leaving the meeting and coming back in.
Let me just try one other thing.
That worked.
Now,
Is it better now?
Yes.
For some reason, I apologize. For some reason, it goes to my computer speaker, which is closed because I have the screen open. And I don't know why it does that. I apologize.
All right. My apologies. I was going to try to share my screen, but my issues with my new computer persist. And I can't seem to share anything. Okay. I'm just going to quickly go over them so that board members, we all remind ourselves as to what the findings for good cause are that are necessary for that finding before we proceed to a hearing on the merits in absence of notice to the public. First of all, number one, that petitioner is in violation of any rule, regulation, or order of the district, or that such violation is imminent. Okay. Two, that the circumstances that were leading to the violation could not reasonably have been avoided by petitioner or anticipated in sufficient time to provide for public notice of the variance hearing. Three, petitioner exercised diligence in petitioning for the emergency variance and scheduling the emergency variance hearing. Diligence in petitioning for the variance shall mean that the petitioner filed a variance petition as soon as feasible after the time petitioner knew or should have known that a variance would more likely than not be needed. Petitioners are urged to file a petition upon acquiring preliminary evidence of a likely violation rather than waiting for absolute certain evidence of violation. Four, a denial of the emergency variance will result in this case, an unreasonable or unavoidable adverse impact to petitioner. And in particular, when we're looking at an emergency variance, we're only looking at that period of time for which the variance is requested. Okay. With that, Mr. Cohen, if you can proceed with an opening statement on good cause.
Okay, good morning and thank you very much. First of all, I'd like to let you know that there will be two witnesses today. Adam Alonso, who's the Environmental Health and Safety Manager for Coast Plating, and Edward Krishnadi, who is our air quality consultant. Petitioner Coast Plating operates a metal finishing operation for the aerospace and defense industries. And that operation includes a chrome anodizing tank with a related control system to control emissions of hexavalent chromium. It's seeking an emergency variance to operate the tank before it obtains a new source test. And I believe we will demonstrate today that we meet all of the criteria. necessary for an emergency variance. Our primary focus will be on whether compliance is beyond the petitioner's reasonable control, because those are the issues that have been raised by the district and on the petition for the ex parte. And we will demonstrate that without a variance, there would be severe economic harm to the company. And in addition, we will demonstrate that during the period that the variance would be in effect, there will be no excess emissions. But nevertheless, the company is taking steps to reduce emissions as much as possible. So I want to give a general description of how this works, how the operation and what happened, and then the witnesses will validate all of that. The operation is essentially a single step-by-step process, of which the chrome anodizing tank is a key element, and that's why the company basically virtually can't operate if it has to if it can't use the tank. I'd like to give a bit of background of how we got to where we are. The chrome plating tank and control system, which includes a mist eliminator with HEPA filters, has 9 HEPA filters. In 2018, the system passed a source test, which was approved by the district. In 2020, one of the inspector looked at that we were required to submit information regarding surface tension, and that information indicated that the surface tension was higher than it had been in 2018. And so the district inspector told us that and said that we would eventually have to perform a new source test for the equipment. At the time, the inspector didn't say and set any deadline for doing that, and didn't indicate there was any problem with continuing to operate during that period. So in October, the company scheduled the new source test, and it was conducted on October 14th. And a couple of weeks later, our consultant, Montrose, came out to look at the system, and it observed some moisture in one of the HEPA filters. And so the company immediately ordered new filters. However, there was a problem because the supplier informed the company that it could take 8 to 18 weeks to get the HEPA filters because they were in high demand because of COVID-19. I guess HEPA filters are also used for health and hospitals and things like that. And so the lead time was very long, though they said they would try to get it to us by December 7th. On November 18th, the company received verbal notification that it had failed the source test. And at that time, it immediately notified the district pursuant to its permit and the rule, and it ceased operations of the tank and basically a good part of the line. Our air quality engineer informed us that the problem was caused by a defective HEPA filter. And at that point, the COSA understood that once it obtained and installed the new HEPA filter, it would be permitted to resume operations, though it understood that it still had to do the new source test. And it was also advised by the consultant to schedule the new source test for a time after the new filters had been installed and were shown to be operating correctly, which to the company made sense because we didn't want it to pass the new source test. Now, although the company was originally told that the filters would ship on December 7th, they didn't. They were then told that they'll ship on the 8th and then the 9th, and finally they got them, I believe, on the 10th. They were installed on the 11th, and on that day, the company informed the district that it was resuming operations. And so we notified the district and resumed operations. At that time, the district inspector told the company that it was his opinion that they couldn't restart until they had a new source test. So at that point, that was inconsistent with what the consultant had informed us, so that consultant scheduled a meeting with some other people at the district that was held on December 15th. And at that meeting, they confirmed that the district's position was that they could not start operating again until they had a new source test which showed compliance. At that point, the company immediately asked its consultant to start preparing a variance application and located me to help represent them in this matter. And the variance application was filed on December 22nd. So, I mean, that's kind of the basic background of how we got here. I mean, I think most of this is not based on any desire by the company not to act properly and not to act expeditiously. It seems to be primarily associated with the difference in how the consultant, the company interpreted the rule versus how the district interpreted the rule. There was certainly no intent to not comply and not act expeditiously. Otherwise, they wouldn't have shut down and notified the district immediately. But in addition to that, we will also demonstrate that the emissions during the period the emissions during the variance period would not exceed the emissions allowed under the permit. And this is largely because the permit assumes that the equipment will be operating all day. And in fact, the equipment's only been operated relatively limited amount, and therefore the levels of emissions are significantly below what would be allowed on a daily basis under the permit. So that's kind of the basics how we got here. And now I would like to call on my first witness, if that's okay.
I'm going to just hold that for a moment. I'm going to go to Ms. Honey-Zavra, who's going to give the district's opening statement, and then we'll come
Oh, I'm
back.
sorry.
Ms. Honey-Zavra, your opening, please, on good cause.
Good morning, Chairwoman Prusak and members of the board. Good morning, petitioner. The district has some concerns regarding good cause. In the view of the district, the issue here is fairly discreet and simple. I just want to make sure that it doesn't get lost in some of the discussion as we move forward through the day. As you're aware, an emergency variance can only be heard if good cause exists to proceed without notice to the public. And there are 4 components of good cause per the hearing board's rules and procedures. And at issue here at this phase is one of those components, which is whether or not petitioner exercised diligence in petitioning for the emergency variance and scheduling the hearing. Diligence requires, as the chairwoman reviewed this morning, that the petitioner file for a variance as soon as feasible after the time that petitioner knew. And what's important here is whether they knew or should have known that a variance would more likely than not be needed. And petitioners are urged to file a petition upon acquiring preliminary evidence of a likely violation. So it's the district's view that petitioner, like all members of the regulated community, is on notice of all district rules and regulations. The burden is not on the district to affirmatively inform petitioner of its obligations or the status of its violations. The onus to comply is on petitioner. Petitioner should have known that it was operating without the benefit of a passing source test. They were informed in mid-November that they most likely did not pass their source test. They informed the district of that failing source test on or about November 18th per the rule requirements. However, it was not until on or about December 18th, which is about a full month later, that they attempted to initiate the process of seeking emergency relief. So in light of the foregoing, and I just want to stress there are probably other facts, but I'd like to boil it all down to diligence here at this phase. But in light of the foregoing, unfortunately, the district must oppose good cause.
Sorry, finding my mute button. Thank you very much for your opening. Okay, Mr. Cohen, if you can introduce your first witness on good cause.
Okay, thank you. My first witness is Adam Alonzo, who is the environmental health and safety person for Coast Plating. Mr. Alonzo, could you please introduce yourself? Yeah, it's on mute.
Good morning, Chairman and AQMD representatives. I am Adam Alonzo. I'm the EHS manager here at Coast Plating, also doing business as Valence Surface Technologies. I've been doing EHS work for various companies since 2015. And I have some experience working with the AQMD in the past.
And
And
could,
I'm sorry to interrupt. What I should have done at the beginning of the hearing is what I started doing yesterday. And I should introduce, since we're on this Zoom call and it's very hard to tell who is who, I'd like to introduce the members of the board. And that way everyone knows who we are, and who they're addressing. Again, I'm Julie Prusak. I am the current chair and the legal member of the board. We have Mr. Mohan Balagopalan, who is the current vice chair. And he is the engineer member of the board. We have Senator Nate Holden, who is a member of the hearing board. Also, Dr. Alan Bernstein, who is also a member of the hearing board. And finally, Cynthia Verdugo Peralta, who is also a member of the hearing board. And after that, sorry, and if Mr. Alonso can just indicate that you took the oath as well, and then you may continue.
Yes, I did.
okay. And could you briefly describe your educational and work background?
I have an environmental engineering degree from UC Riverside, and I've worked in environmental health and safety at chemical manufacturing companies, other aerospace companies, LAX as well. So a very varied experience, I would say.
Okay. And can you please describe what coast plating does?
So we're a metal finishing facility, and it's two processes. There's the wet line, which applies metal coatings via chrome plating or chrome anodizing, hard anodizing. We also clean the metals in the wet line. So ultimately, it's a series of processes to prepare the actual metal surface with new coatings to make it more durable and weatherproof, as well as some military specifications. And then after that process, there's the painting, which applies top coat, primer, dry lubricant, and all sorts of other metal coating finishes for aerospace.
And who are its customers?
The end clients would be Boeing, Northrop Grumman, other defense-related contractors, and we also do work for their intermediates. So we have business with Alcoa, Acromil, Precision Cast Parts Corporation. So the end user ultimately is going to be an aerospace company, but we do business for a variety of their intermediates.
And is it considered, is coast plating considered an essential business for COVID-19?
Yes, it is considered an essential business because of the military application here.
And now, can you please describe the control equipment that's at issue here today?
So the chrome anodizing tank is connected to the air pollution control equipment, and that equipment starts with the vents. So there's the air that's pulled out from the surface of the tank, and then that goes into 3 stages of mesh mist eliminator pads, which are supposed to remove the moisture. It then passes through a panel of 9 pre-filters, and then finally the panel of 9 HEPA filters before being exhausted to the ambient air.
Okay, and do you know what the efficiency? Okay. Now, can you briefly describe the regulatory history of this control equipment? When was it originally permitted?
So the equipment itself, I think it's in one of the exhibits. The permit to operate it's in the attachment SC AQMD rule 203 and 1469. That includes the permit. And so that was effective June 5th, 2014. And it includes the chrome anodizing line and the air pollution control devices.
And the air pollution control device, did that have to go through a source test?
The air pollution control device goes through a source test initially when it starts up, and then it's done again on a recurring basis according to the rule.
And did it pass the source test in 2018?
Yes.
Now, can you explain what happened that led to the variance request here? Why is it that you did this source test in 2020?
At some point prior to this, the AQMD requested that we do another source test because of the discrepancies between the surface tension in the source test prior to that and then the one in 2018. And so we scheduled it for October 2020, and it occurred on October 12th. And during the process, everything was running as usual for the source test. We had a member from the AQMD came out to observe us setting up the equipment. And then the source test was completed. During the day of the test, we had no reason to believe that it would fail. And then on the following weekend of October 24th, the project manager from Montrose came out to do visual observations because the Montrose employees that came out, they're just technicians. They just did the source test. They didn't do any additional work. But the project manager did come out and do the visual inspection. At that point, it was noted that there was some moisture inside the housing for the HEPA filters. And so at that point, we went through the process of ordering more HEPA filters to replace these in the event that the source test failed.
Let's go back. Sorry, go ahead.
Oh, no, go ahead.
Just go back a little bit. When the district informed you that you should do another source test, that was in June or so, I believe. Is that correct?
Yeah, it's prior to my employment here, but I did have the historical email record. I think it's in one of the exhibits. It doesn't specify a time frame for retesting. It's just a request to do it again.
All right. And did they to your knowledge, did the district set a deadline for conducting that test?
No, I don't have any knowledge of a deadline, and there was no indication that we would be out of compliance for not doing it by a certain time either. We were still operating as though we were in compliance. Because of
okay. And did you have any reason to believe at that time that the control equipment was not sufficiently controlling the emissions such that it wouldn't meet the permit levels?
No, because of the passing source test, we believe that the pollution control equipment was operating efficiently and correctly.
Okay. Okay. Now, you said that on October 24th, the inspector, your consultant, the engineer, informed you that he had observed moisture in the housing for the HEPA filters. What did you do in response to that?
We proceeded to find a vendor to order more of those HEPA filters in the event that they were damaged and we would be failing the source test. And so that process actually took much longer than usual. In the opening statement, the hospital industry is actually prioritized for receiving the HEPA filters at this time. So we were, kicked down to a longer time frame because those are being prioritized for COVID relief. And so normally under normal circumstances, it's basically a 2-day turnaround time to receive these. So we would have been able to replace them as soon as we knew that something visually was wrong, even before receiving a failing source test.
Okay, and when you contacted the supplier, what kind of time frame did they give you on what the lead time was for delivery of HEPA filters?
So in Exhibit 4, you can see the supplier let us know it was going to take 8 to 18 weeks, and that the best delivery they could offer was for December 7th.
Okay. Now, I will get to maybe a little bit more detail later, but did you, during the period between, well, sorry, let me go back. So now what happened on November 18th?
So on November 18th, we were contacted by Montrose over the phone to let us know that we had failed the source test. So we didn't have a written documentation at that point, but we did have the verbal confirmation.
All right. And okay, and around that, at that time, did you know, did Montrose have an opinion as to what had caused the failure to fail the source test?
In our conversations with Montrose, because every other aspect of the pollution control was operating correctly, the only thing that could have been left was the moisture on the HEPAs.
All right. And what did you do on November 18th upon learning that that there was a problem, that you failed the source test?
So my superior, the vice president of environmental health and safety, Corey McGraw, he called the hotline that AQMD provides for reporting exceedances, and he also emailed the confirmation of that conversation, that phone conversation, to Marilyn Potter at the AQMD. And on our side, on the production side, we stopped operations that day.
Okay, and now what happened with the filters? Did you attempt to expedite getting new filters?
Yes, we ordered the ones from our regular supplier, Pure Process Filtration, knowing that they would come on December 7th. But in the meantime, we looked at other options, so other filter vendors in this area, to see if we could maybe pick something up locally. We did try using Florence Filter Company. They said that they had something that was a one-to-one match. We tried to install it and it didn't fit. It's the wrong type of gasket that connects to it, and then it did not have the gel seal that was required. So we also looked at a couple of other vendors, and none of them had exactly what we were looking for. They all would have been a poor fit. It wouldn't have met the requirements either of the permit.
All right, and on November 18th and around November 24th, did you believe that you needed a new source test in order to resume operations if you replaced the HEPA filters?
No, we were under the belief that if we addressed the root cause, the issue that was causing the exceedance, then we would just let the AQMD know that we addressed it, and then we would be free to operate.
Okay, and why was that your understanding?
That was my understanding because whenever a HEPA filter is changed in any other pollution control device, whether it's a paint booth or on the chrome anodizing line, we don't have to inform the AQMD that we did it. I mean, it's just part of the regular operations and maintenance of the machines.
Okay, and now did you try? I think originally the supplier said they would ship them on December 7th. Did they ship them on the 7th?
No, they did not.
And did you call them and contact them and try to get an earlier date as soon as possible?
Yes, we were in constant phone communication with them, and we actually bypassed the supplier to get them here quicker. So the supplier let us ship direct from their manufacturer to our facility, and even with that process, it still didn't get here until the 10th.
Okay, now I think you said that you didn't believe at that point that you needed a new source test to resume operations, correct?
That's correct.
Okay, now and nevertheless, did you consider scheduling a source test as early as possible once the filters arrived?
Yes. At some point after knowing that we failed, I can't give you the specific date. I think it's in the exhibit somewhere. We contacted Montrose, and we tentatively scheduled the source test to be redone on the 12th. But because we were having such an issue with our supplier, we couldn't be confident that the filters would be on site and installed by that time. I mean, she gave us the best option of December 7th, but that's still within the window of 8 to 18 weeks. It could have came later than that, and we would have been, up in the air, and we would have hired Montrose to come in on a Saturday for nothing when it wouldn't have been replaced in time. So not only that, but it actually does take some of our production employees to run the line when Montrose does the source testing. So it would have been a commitment to bring people in unnecessarily, basically. So we didn't have the 100% confidence that the filters would be here by the 12th for us to do the source test, retest on the 12th.
Okay, and also did Montrose advise you regarding when you should conduct the source test once the filters have been installed?
Yeah, we did. We did talk to them about getting it done as soon as possible after the installation, but due to COVID and the holidays, there was no available time between the 12th and today to get it done.
And is the source test being conducted today?
Yes, they started already. It's in process right now.
Now, did Montrose also advise you that it's better to allow the the filters to be installed and operate a little bit before you conducted the source test?
Yes, they did advise us that there would need to be, a big enough buffer to troubleshoot problems in case there were any. So us doing the source test on the 12th, even if we could have, would have not been a big enough buffer in case we had system issues. And even so, on the 11th, we didn't even have them running on the 10th. We had to wait until the 11th to get all the electrical back up and running. So even if we could have done it on the 12th, we would have only had about 4 hours of buffer time at the end of the shift on the 11th before the source test would be done on the 12th.
Okay. Now, did okay, why don't we go to so now, what happened on the 11th? Can you tell us what you did?
So
what the company did?
11th of December, we informed the AQMD that we had changed the filters, that we were going to resume operations. And at that point is when they told us that we were not authorized to resume operations.
And what did you do when you learned that?
At that point, we enlisted legal counsel, so we reached out to Loeb and Loeb, and we also reached out to the AQMD. I mean, not the AQMD, our Montrose, so that we would schedule a Zoom call with the AQMD. That was scheduled for the following week, the 15th, because to us, it was really a bit of a surprise that we would not be allowed to operate when it was a changing of filters.
Okay, just to clarify, I hope you don't mind me pointing out, but I was retained after that meeting. I wasn't a participant then on, if you recall that.
Sorry about that. It was done. It was my superior that handled that, so I assumed it was.
Okay. Now that meeting was held there was a meeting with the district on the 15th, correct?
Yes, that's correct.
And who participated in that meeting?
That was myself, Corey McGraw, who's my superior, Edward, who is on the call with us, as well as 2 other members of Montrose. So I believe it was Hugh Brown and 1 other person. I don't remember specifically.
Who was there for the district?
Frederick Chung was there, and I believe it was 2 other people. I don't remember specifically
All right. And what did did you just discuss with them whether or not you could continue to operate um, eh, now that the filters have been installed?
So it was the AQMD's position that we would still be unable to operate, and that if we were going to operate, we would need a variance. And so
Right.
at that point, we begun that process.
And did you initiate the process of attempting to get a variance right away?
Yes, yes.
What did you ask? Is it correct that you asked Montrose on that day to start preparing a variance application?
Yes, that's correct.
And did you retain me a couple of days later to assist with that?
Yes. Well, me specifically,
I mean the company. Sorry, when I say you, I
Yes.
mean the company. I apologize.
Yeah.
Oh, all right. And do you recall what? And I believe that application was submitted on about December 22nd, correct?
Yes, I believe so.
All right. Now, did you believe that when you were applying for the variance that you were doing so expeditiously after learning that you needed the variance?
Yes, because we hadn't been operating from the 18th of November until the 11th of December. So there was no operation time during the time window that the exceedance would have occurred.
What I'm understanding is once they told you on the 15th, after the discussion on the 15th, did you immediately apply for variance?
Yes.
Start the process. Thank you. Now, I guess one of the things we need to talk about is, do you know what rules you would be violating by continuing to operate without the variance?
It would be 1469 and 203, I believe.
Right, and what's the basis for the alleged? What's the basis for the district? What is the district's opinion as to why you would be in violation?
We would be in violation because of the exceedance from the source test. So if we continue to operate without a new source test showing that it's passed, that we would be in violation.
Right. That's the district's position, correct?
Yeah, that's what was discussed and told to me during the 15th.
All right, but that was, just to clarify, that was inconsistent with your understanding before that, correct?
Yes, that's correct. So it was my belief after consulting with Montrose that on the 11th, once we put the new filters in, that we would be able to resume operation immediately because we would have corrected the issue.
Okay, and I believe it's Exhibit 8. I don't know if you have it there. If you could look at Exhibit 8, and I think it's page 3 of that exhibit, you'll see there's an email from Stanley Brown to you dated November 24th.
Yes.
And can you read this? And is that a true and correct copy of the email that you got from Mr. Brown on that date?
Yes.
And just to clarify, Montrose was your air quality consultant, correct?
Yes.
Right. And can you read what he said in that email?
He said, Adam, comma, space breaks. As soon as you put in new filters, you are assumed to be in compliance so you can operate. Make sure you document the filter change date on the log where you monitor the filter pressure drop. And then
Right.
email signature, end of message.
Okay, so so then it was Montrose's understanding that you would be in compliance, you could resume operations as soon as the filters were replaced, correct?
Yes.
And that was your understanding as well, based on your reading of the rule and your understanding of what Montrose told you, correct?
Yes.
All right, now did you, okay. Let me go back. Sorry, I'm just trying to make sure what I covered and what I didn't. Now, when is again, the source test is being conducted today, is that correct?
Yes, that's correct.
And how long would it take? How long do you anticipate it will take to get the results of the source test?
3 to 8 weeks. That's how long it took for the previous time. So we're assuming it'll take the same amount of time.
Okay, and have you asked Montrose to expedite that as much as possible?
Yes.
Okay. Now, why could you have applied for a variance? Had you applied for a variance once you learned that you needed a variance, would there have been sufficient time to provide public notice?
I do not believe so.
And why is that?
Well, we would have to stop the operations and default on some contracts during the time it would take to wait for a public hearing. And so we don't think it was in the best, it doesn't make the most business sense to wait for a public hearing. Like the time it takes to schedule it would be just too long.
And that's why you were, now, is it your understanding that it would take anywhere from 30 to 45, at least 45 days to schedule a hearing?
Yes, I believed it would take at least a month, yes.
All right, and so, but by that time, you would have already had the results. You would be about the time you would obtain the results of the source test that you had already scheduled, correct?
Yes.
So, and that's why you felt the need to get an emergency variance. Is that right?
Yes.
All right. Now, let's see, okay. Now, by the way, when Coast scheduled the variance for January 7th, which was the earliest date that Montrose gave you, did the company ask Montrose if there were any other earlier dates?
Yes, we did discuss this with Montrose, and there were no other available dates between the 12th to the 7th, the 12th of December through January 7th.
Right. Okay. And did you also check with other other companies to see whether or not they had any dates available?
Yes, my supervisor, my superior, Corey, reached out to multiple different companies that do the same consulting work that Montrose does, and the lead time was even longer.
All right. Now, I'd like to go back with regard to the HEPA filters. Does Coast have an operation maintenance plan with regard to the control system?
Yes, it is my understanding, yes.
Okay, and do you know how often it inspects the HEPA filters and replaces them?
I couldn't tell you off the top of my head right now, but I know that it's called out in the plan.
Okay, and you don't have the plan available right now?
I can open it up on my computer if you'd let me.
Okay, we might want to come back to that after.
Yeah.
So when I have the next witness, if you can look at that, because I might have some follow-up questions. Do you know when Coast had last replaced those HEPA filters?
Yeah, it was my understanding that they had been done over the summer prior to my employment here.
Okay, so you were told by the company that they had been replaced about July, is that correct?
Yeah, sometime between May and July, according to the maintenance staff.
Okay. And is it your understanding that they are monitored on a regular basis?
Yes, it's my understanding that there's a routine maintenance schedule for this.
Okay. Sorry, just give me a second so I can catch up. Now, I believe that the reason that the district had asked you to do a new surface test was because of difference in surface tension. Is that correct?
Yes, that's correct.
Okay, and now, do you know why surface tension is something that's measured with regard to this kind of operation?
In the past, it was allowed, the use of mist suppressants, chemical mist suppressants was allowed. And at some point between then and now, there were requirements to stop using it. And so coast plating in the past had used a chemical mist suppressant as a way to reduce the emissions, and now was no longer using that product. And so that's the thing that would change the surface tension, is because it would change the chemical composition of the chrome anodizing bath.
Okay, now when the 2018 test had been done, was coast plating using suppressants?
No, they had not been using chemical fume suppressants at that time.
And are you aware, did they change the liquid in the tank prior to the source test in the 2018?
Yes, the bath liquid, the chrome anodizing solution, is changed regularly to maintain the concentration.
Right. So your understanding is that it was replaced prior to the source test in 2018.
Yes.
Now, did you have any reason to believe that the change in surface tension would render the company not in compliance with the permit limit?
No, I don't believe that would change whether we're in or out of compliance.
And why is that?
Because all of the other pollution control devices are in operation as is called out in the permit. So the 3 stages of mesh pads and the HEPA filters and everything is as written in the permit.
All right. Now, if coast plating is not permitted to continue operation, what would be the economic impact on the company?
Well, a lot of the contracts are bundle contracts. So we do chrome anodizing for certain parts for a variety of customers. And then that allows us to do the non-chrome plated parts as well. So if we were to lose the chrome anodizing process, it would basically render the contract void because of all of the other products that we process would also have to stop being processed here because it's all under the same contract. And so we would have to dramatically reduce operations. It would probably cause about 85% of the staff to be laid off because of the number of products that go through here that pass through the chrome anodizing.
And let's go back at the time that you shut down between November 18th and you resumed operations. Do you know how much that shutdown cost the company?
I do know that we lost 7 employees because there was no longer the work to justify having them here. And we also did lose we lost some product throughput going through here. I believe that the actual financial, the number amount, the dollar amount is in one of the attachments.
Okay. Is your understanding there was about $400,000 in lost income
yes.
because of that?
Yeah, I think that's a good estimate. It was about $400,000.
Now, if you had to shut down, do you know how would that result in any loss of customers?
Yes, if we had to shut down the chrome anodizing line for a prolonged period of time, we would lose most of the big contracts because it would be a breach of contract and we'd be financially liable to the customer as well.
Now, do you believe, given the circumstances and your understanding, that you did that the Coast did all it could in an expeditious manner to repair the control equipment?
Yes, I think if you look through the exhibits and see our communication with our supplier about how quickly we get the HEPAs and then all of the other things, all the other actions that we took in the interim, we were getting this done as quickly as we possibly could. And then,
And sorry.
and you know, the notices to the AQMD were also done as soon as we found out that we would need to do some of these things, like the petition for variance. We did it right as soon as we found out. So as soon as we were notified, we went ahead and, you know, went through the process.
So you believe that you expedited in as expeditious manner as possible to schedule the source test?
Yes, that as well. We scheduled it for the soonest we possibly could, even before knowing that we failed the previous source test. We went out of our way to reschedule one. So.
Okay, and do you also believe that coast plating acted as expeditiously as possible with regard to applying for the variance?
Yes, I also believe that as well, because as soon as we were informed of the need to do that, we did it.
Okay, so I have no further questions for Adam. Does the district, I guess district might have questions?
Yes, I'm going to turn it over to Ms. Honeyzabra for questions for Mr. Alonso.
Good morning, Mr. Alonso. I have a few questions. Let me just go through my notes a little bit. Let's see. I kind of want to focus in on the issue of the compliance with the rule and the issue of the HEPA filter. So are you familiar with Rule 1469?
Yeah, I have taken the Rule 1469 training, yes.
Okay. And once you failed the source test, but replaced the HEPA filter, what made you think that you were in compliance with the rule?
There's a specific section of it that calls out, let me see if I can find it in the exhibit.
I think it's Exhibit 2.
Exhibit 2 is not the entirety of the rule, so I don't know.
Yeah, I don't think that's the whole.
Alonso, do you have an ability to pull up the rule on your computer or otherwise?
Yeah.
It's on the AQMD website, if you can do that, which is aqmd.gov. You might want to also refer, do you have the petition in front of you?
Yes. Let me.
I don't have page numbers on my petition, but it looks like you might be discussing this on the top of page 3. of your petition, if that refreshes your recollection.
14, yeah, so 1469 P4.
Okay.
Let me-
So section P4 is a notification requirement, but I want to draw your attention to the emission limits requirement of Rule 1469. So I'm looking at section H2, and I'll try to find it in the petition and in the rule simultaneously so that everyone can take a look. It's on page 17 of the rule itself. And then it's on the 19th page of the petition. So once the facility notified the district of the failed source test, was it under the belief that all it needed to do was notify the district and then it would continue to be in compliance if it operated?
No, it was our belief that we would notify the district and then rectify the issue that caused the exceedance. And after that, we would be in compliance.
Okay, so in other words, once the source test was failed and the facility understood that it needed to rectify the issue, which was the failed source. Let me back up, sorry. What was the issue that the facility believed needed to be rectified once the source test was failed and the notification was issued?
We believe that the issue had to be the HEPAs because there was no other system that was outside of the operating range.
Okay. So within the rule, and again, I'm looking at that section H2, there are certain emission limits. Once the source test was failed, how was the facility able to show compliance with those emission limits?
So for the time between the date of the source test and the date that we were notified, so between October 12th and November 18th, during that operating period, we have the logs from the rectifier that show the amp hours that it was used. And so we were able to calculate emissions based on the chromium concentration in the source test over that amp hour time period.
Okay. I'll draw your attention back to the rule. Again, I'm looking at page 18 of the rule itself, and then within the exhibit, I'm looking at page 20. So table 1 of Rule 1469. There are certain emission limits that are required to be met, but if you take a look, footnote 2 of table 1 requires that those emission limits be demonstrated by source test requirements. So at that point, although you were able to calculate excess emissions, was there any follow-up source test at that time that demonstrated compliance with the emission limits once the October source test had failed?
No, there's no source test between October 12th and current date.
Okay. I just have a few more questions, sorry. Can you elaborate a little bit about why the follow-up source test was scheduled if you believed that you were in compliance once the HEPA filter situation was rectified?
So because of the failed source test, we would need a passing source test no matter what. And so on November 18th, that we found out that we had the failed source test, and then we went ahead and scheduled a new one. That was to get a passing source test, not necessarily to to deal with the root cause. So the source test to us is just like a measurement and indicator of how we're doing versus changing the filters would be the action needed to do to get in compliance. And so it's our belief that if we pass the source test that's being done today, then that passing amount is applied to the time window from December 11th to now, because those are the existing conditions at the facility from that point until current day.
To clarify, you mean if it's passed now, you mean that it would be an indication that there were no excess emissions from December 11th moving forward?
Yes.
Okay. So you indicated though that you knew that you needed to do a follow-up source test, but that process wasn't, rather the process of getting coverage didn't happen until a month later. And by coverage, I mean emergency variance relief. So one of the components of good cause that we've been talking about is diligence. So once you knew you were in violation or would imminently be in violation, it was up to you to go ahead and kind of initiate the process of getting coverage. So why did it take a month from, I think it was November 18th to about, I want to say December 18th or so, to kind of kick off coverage, to kick off the process of getting coverage?
December 22nd is the date of filing.
Okay.
So
you're
for the time between November 18th through December 11th, we did not operate the unit. And so during that time, it was our belief that we wouldn't need a variance if the equipment was not in use at all. It was completely shut down. And then on December 11th, we were under the belief that as soon as the issue was fixed, that we would be in compliance, and that once we did get a passing source test at the point in the future, it would retroactively be applied from December 11th onward. And so there wouldn't be a need for variance at that point.
What can you explain the basis of that belief? I know it's kind of a repetitive question, but if you can explain why you thought that.
Well, the operating conditions would be the same from December 11th until the date of the source test now. So there is nothing that has changed at all in the process. And so that time window is indicative. So the source test that we're doing today is indicative of the emissions during that time window.
Okay. Let's see. You mentioned briefly, these are kind of clarification questions. You mentioned that you or your superior checked with other companies to see if they could schedule a source test. Do you recall how many other companies or which companies they were by any chance?
I wasn't a part of those negotiations, so I would defer to my superior. I couldn't tell you specifically.
And then the meeting with district staff in Montrose, can you clarify the date?
That was on Wednesday, December 15th. Oh wait, no, Wednesday, December 16th. Let me pull up my calendar real quick.
Sure.
Yeah, Wednesday, December 16th, we had that call with the district and Montrose.
Sure. Okay, thank you. Actually, sorry, a couple more questions. You mentioned in your testimony that the meeting was held because it was a bit of a surprise that they were not allowed to operate because the filters had been changed or the filters would be changed. So you're implying there, and again, it may, I'm just trying to get at what the specific violation is here that you thought was occurring. What you thought there was that it was, once the filter was changed, or I won't put words in your mouth. Why was it a bit of a surprise that you were not allowed to?
We were operating under the assumption that once the filters were changed, we would be in compliance again.
Okay.
And so, I mean, on other other processes that we have here, we change filters regularly, and we don't, inform the AQMD of every time we change something. It's just a normal operating process. So we thought it would be the same.
Sure. But that the results of the failed source test did, sorry, let me back up. But there was no, once the source test was failed, you, did you recognize or realize that there was a basis in the rule for, sorry, I want to back up and be careful about how I ask. Once the source test was failed, or you were informed that it was going to fail around mid-November, was it your understanding, though, that you had to conduct a source test, retest, to comply with the rule requirements?
Yes, it was. So it was our understanding that we need a passing source test to operate, and that because of the operating conditions being the same from December 11th onward, we could just apply whatever future source test we did to that time window. So that was how we were justifying this.
Okay. And last question. The reason you believe that was because of your discussions with your consultant, or what was the basis for believing that operating conditions could kind of provide that sort of coverage?
Yes, that was a call that we had with Montrose as well. So we went over this and we were in agreement.
Mm-hmm. Okay. I think that's all I have for now for the witness.
Thank you. I had a few questions. You keep saying that you do this a lot, where you replace HEPA filters elsewhere in the facility, and you don't inform the district every time. But don't you, I mean, truly, don't you see that there's a difference between failing a source test and simply just replacing a HEPA filter? I mean, let me
Yes,
step.
there is a difference, but I mean, in my mind, it was not as that big of a difference that would be covered under like two completely separate rules or regulations. Like to me, it was similar enough.
Similar enough. So have you ever had the situation where you've replaced a HEPA filter because of a failed source test?
No, I've never experienced this before.
So this is very different, wouldn't you say, than any other situation you've had?
Well, it's not necessarily a different process in my mind. It just the way the rule is applied is different. And I mean, like I said, I've never dealt with an issue where a source test failed before. So
Let me ask you this question. You testified, and you know that the reason why the district asked for an additional source test in the first place was because of a change in the surface tension. Is that correct?
yes.
Okay. So then, is it your knowledge that differences in surface tension might contribute to differences in ultimate emissions of hexavalent chromium?
Yes, I do know, I am aware that there is a relation between the surface tension and the chromium emission.
So how could you, and I don't mean just you, I mean, how could your company, sorry, I just want to get it right, Coast Plating, sorry. How could you know for sure without another source test that in fact it was just the HEPA filter that contributed to the failed test and not the surface tension for which the test was requested in the first place?
Well, the discrepancy that had been historically noted was between a source test done in 2010 versus 2018. So the operating conditions in 2018 for the tank itself of not using chemical mist suppressant, those are the same operating conditions as now. So if the source test was going to fail for the surface tension, it's my understanding that it should have failed in 2018.
Okay, so your testimony now is that nothing changed between 2018 source test and the 2020 request for a source test? I thought the whole premise of the requested source test was a change.
There was historically a higher surface tension when the chemical mist suppressants were being used, and Coast Plating had stopped using them already by that point. So the operating conditions between 2018 to now regarding the concentration of the tank would be the same. So the lack of chemical mist suppressant in the tank would be the same from 2018 to now.
Okay,
The difference in operating conditions is not necessarily between 2018 to now, it's between 2010 to 2018.
okay, I'm just trying to get at the reasonableness of determining without a source test to know that it was definitely these filters, and so you're compliant without a source test. I'm not sure, I'm trying to understand how that's reasonable, but okay. What about the fact that a filter has excess moisture? Is that something that you should know would more likely than not create higher excess emissions?
If during the course of routine maintenance we do observe excess moisture, then yes, that is a red flag, but the moisture wasn't observed until the 24th.
Okay, so that is a red flag.
Yes, but we don't have any historical record of it being exposed to moisture until the 24th.
Okay, but it is a red flag, is that correct?
Yeah, it's
It's a red flag.
alarms, yeah.
Okay. So, and you just answered my next follow-up question, which is on October 24th, Montrose did an inspection and found that HEPA filter had excess moisture, correct?
Yes, that's correct.
So why didn't you stop using or consider at that point that you were likely to be in excess of hexavalent chromium limits and at least look for variance relief or something like that? Did you have any reason to know?
Well, we proceeded with purchasing the additional HEPA filters to replace those that had moisture. And so without the results from the source test, we can't say for sure what the data will show, whether it's a failure or not. I mean, my description of this as a red flag is just, it's something like a check engine light on your car, where it might be nothing, it might be something, but you can't say for sure the severity of it without the results of the source test.
Why did Montrose come and inspect on the 24th after the source test? Was there an indication, a preliminary source test result that was received, or an indication during the testing that there might be an exceedance?
We were informed that there were irregularities, but we didn't get any quantity, any number. Like there was no concrete data to show us that there was anything explicitly wrong. We just knew that there were irregularities.
Okay, so on October 22nd, that was the date of the test?
No, the 12th.
On October 12th, you knew that there were irregularities, but you didn't.
No, the October 12th is the day of the source test. Mm-hmm. And then at some point, I mean, I would have to look through my records, but at some point prior to that, the project manager from Montrose let us know that there were irregularities, and then he came on the 24th.
Okay, so sometime between the 12th and the 24th, there were reported irregularities from the source test. As of October 24th, Montrose came out and saw for a fact that there was excess moisture in the HEPA filter, correct?
Yes, that's correct.
Okay, but at that point, no one thought that there was that it was more likely than not, or that there was a probability that there might be a failed source test, and perhaps you should seek a variance relief.
Well, we didn't have any concrete data to support it other than the project manager telling us that there was irregularities. Like he could not guarantee to us that it was going to fail the source test.
And then November 18th, you received those source test results, but you shut down.
Yes.
Okay, till December 9th. No, 10th.
No, the 11th. December 11th.
Okay. December 11th, an inspector informed you that it was the district's determination that you needed another source test in order to start back up operations. Is that correct?
Yes.
Okay. So you had reason to know at that point that the district was going to see or to consider you in violation if you started up without a source test, correct?
Well, that was part of the reason for the phone call on December 16th is because we didn't understand what justification the district was using to say that we would need the source test prior to beginning operation. Because I mean, the source test has to be done when it is in operation in the first place. So there would have had to be some level of operation just to conduct the source test anyway.
Is there a reason why it's not usual practice to have HEPA filters on hand in case they need to be replaced? You said that this is pretty routine that you replace HEPA filters.
Yes, and our supplier normally keeps these in stock for us. And prior to COVID, we had no delays. There was no issue. And so when we were attempting to purchase them for this replacement, we were informed that there would be an issue because of COVID.
Why keep them with your supplier? Why not have them on hand?
It had never been an issue before. We were always able to get them within 2 days.
When was the last? Okay, July was the last time this one was replaced. What about any other HEPA filter?
Yes, the other HEPA filters actually we keep in stock, and the supplier keeps in stock for us, and we've never had an issue with those. Like the ones that we use for the paint booth right now, we're able to get. There is some delay, a bit of a delay because of COVID, but it's not enough to impact operations. So these specific filters had a much longer delay than the ones that we use for the paint booths.
You mentioned also that if you were not granted a variance today, that you would start to lose customers. Okay, so from November 18th through December 11th, you did not operate. Did you lose customers?
We lost jobs for customers, so there was a substantial amount of work that we no longer could process for customers, and so those jobs were, we forfeit them basically.
Okay, and
so it had not been a long enough time period of being out of operation to lose a whole customer, but it was enough to lose contracted jobs with customers.
I wanted to correct something that was asked earlier about the time it takes to have a noticed hearing for a short variance, which is what you would want, given the amount of time you were requesting. It only takes 15 to 21 days, 21 days max to get a hearing. Yet on December 11th, you knew for 100% sure that the district was taking a position that you would need a variance because you would be in violation, but you waited till the 22nd. That was another 11 days. Were you not concerned that you would be losing customers in that time frame?
Well, we believed that when we talked to the district on the 16th, that the district would agree with our position that we could begin operating again, and then in some point in the near future get the source test to retroactively cover that time period.
And then today I just wanted to make sure I understand. You're asking for relief from the actual limit for hexavalent chromium. Your position is a little bit contrary. So I'm trying to understand, your position is there are no excess emissions because you are in compliance and you don't really need a source test to continue operating, but you're requesting a variance today from excess emission limits. So I'm trying to understand why.
Well, that's because this process is what we were told by the district is what we would have to do. And so doing the calculations for the emissions based on the amp hours and the average, and the source test results, we personally, from the calculations, don't see any exceedances except for the ones on the day of the source test itself. And that's because it was being run for the whole 8-hour period of very heavy processing to comply with the source test. And so for every day after that, we only use it for an hour or two every day, and so we are able to stay under the emission limit.
I would be I just want to be clear, I'd be very hesitant to give any kind of variance from hexavalent chromium limits when the entire theory of the case is that you are not in excess of those limits. So I want to have a better understanding of what is it. I see also you're citing Rule 1469H4 with regard to the need for a source test. Is that it? You want to be able to operate in absence of the second source test?
Well, we are having the source test done now, presently, and we just need the variance to cover the time period where we were operating without the source test.
Okay.
And so it would be a retroactive thing, which I think you explained that it doesn't work that way. So that was not really my understanding prior to this.
Okay. I just want to be clear that it is contrary position to say that you're not in exceedance, but you want a variance from the limit. So it would really be a request, I assume, to continue to operate without a source test or a passing source test. But okay, we'll deal with that when it comes to it. I'm going to turn it over to my fellow board members for questions on good cause. Ms. Verdugo Peralta and then Mr. Balagopalan.
Thank you, Madam Chair. Mr. Alonso, how long have you been with Coast Plating?
Since July, let me.
Just approximate.
I started over the summer, so I started July.
So less than a year.
Yes.
Okay. How long has Montrose been their contractor?
Historically, I think all of the source testing for everything initially was done.
In time, how long in time?
I would say at least since 2010.
Since 2010, okay. So when you're saying, you keep on saying, we thought, our understanding, are you stating that is just Coast Plating? Are you stating that on behalf of just Coast Plating? Or are you stating that in conjunction with Montrose?
Well, I'm only speaking about Coast Plating individually, but in the context of the conversation we had on the 16th, we are both of the same opinion. So Montrose and Coast Plating is of the same opinion, and so those I've stated together.
Okay, now in your previous employment, have you dealt with the AQMD rules?
Yes.
Okay, so when you had these discussions with Montrose, it sounds like you just took them at their word. And I don't see any question that you could have and should have had that there was any thought at all to contact the district and actually get better information. I would think that at the very beginning, when there was some type of a question and or they were making an actual statement, you will not be out of compliance, my first indication would be look up the rule and read it completely. If you're still in doubt, call the district. But I don't see anywhere that that occurred until very late in the game here. Would you agree with that?
Well, I would say that because Montrose and Coast were of the same opinion, that it did not, there was never any, there's never any discrepancy between what we believed and what we as Coast believed and what Montrose believed. And so we did not, and we did look up the rules, 1469, and we went over it together. But the way that we were interpreting them didn't give us cause to contact the district.
And nobody in that meeting had any doubt at all that the path that you were taking was absolutely the correct path. Is that correct?
Yeah, there's no indication that we had been doing anything wrong. I mean, obviously the failing source test is wrong, but procedurally there was no indication that we had been, filling out paperwork wrong or submitting things wrong or applying for things wrong.
Okay, well, I understand that you've been there a short amount of time. Are you aware of any previous time that Coast Plating had any type of similar situation that they were out of compliance with AQMD's rules?
I do believe that there have been compliance issues in the past, and there have been issues noted when Fred Chung comes on site to do inspections, and so those issues have not resulted in as severe a penalty as what we're dealing with now.
Well, my concern is that you're a company that responds to the aerospace industry, which is very important, yet I don't see a due diligence here regarding making sure that you're in compliance. I mean, I don't think it would have taken anybody too much time to just pick up the phone and verify that the information that your contractor was giving you was correct, because it's your neck. It's your contract with the aerospace company that you're dealing with, that your responsibility to them is to provide the product that they're asking for. And if you're out of compliance, you obviously can't go forward doing that. So my concern is if there wasn't a verification of how the rule was being interpreted and you only took the word of the contractor, well, I understand that's what you hired them for, but also within your position, you're the environmental, let me get this again, you're in the environmental health and safety person there at the company, correct?
Yes.
Okay, so in that position, that's a very responsible position. I would also have called the district, I would think, to just verify, if nothing else. So hopefully this is a lesson for everybody here that that needs to be done. I don't have any other questions at this time. Thank you.
Mr. Balagopalan, you had
Do you
questions.
do you want to take a break first, and then, because I have several questions. So
Yeah, I think we should take a break. I apologize for the lateness of a break, but I just realized what time it is. So let's take a 15-minute break so everyone can stretch and do what they need to do. So let's be back promptly at 10:55. And please do not leave the meeting during the break, because you might have trouble getting back on. But definitely make sure to please mute your microphones if you haven't already, and you can turn off your video if you need to. So we're off the record until 10:55. Thank you. It's just about 55, so we can start reassembling. I'll make sure we have Senator Holden, and then we can. I think we have all the other members. There we go. Okay, we are back on the record, and when we left off Mr. Balagopalan, it was going to you for questions.
Thank you, Madam Chair. Mr. Lanzo, I was actually confused reading the petition, but I think Mr. Cohen's questioning of you clarified some of the things on why a retest was done in 2018 and then subsequently in 2020. And I just want to clarify that for the record. The equipment has a permit to operate. So assuming, and I think you indicated it was issued in 2014. So a source test was done thereabout prior to that. Do you know when the source test was done before the permit to operate was issued?
I believe it was 2010, but I cannot say for sure. I don't have those records in front of me right now.
And the rule requires subsequent test every 5 years. You're aware of that?
Yes, I'm aware of that, and I know that's why they had been done in the past.
And then 2018 was the test that was done, which indicated compliance with the limits.
Yes.
Now, you mentioned that in 2018, when the test was done, there was no fume suppressant at all in the tank. It was been removed and a new solution was placed without any fume suppressant.
That's correct. Yes.
Was any readings taken of the surface tension to your knowledge?
The laboratory keeps historical data of that nature. I don't have access to it right now, but I can find out.
It's okay. And then come 2020, the inspector was out there, and the reason he asked for a source test was because you failed the surface tension reading?
Well, the source test didn't fail, but the surface tension reading was, in the opinion of the inspector, it was irregular with what was expected if there were no fume suppressants in the tank.
And did the inspector indicate what the reading should be, or what?
There is some amount of dynes, I believe it is, that is required, but I would have to defer that question. I'm not 100% sure.
So nevertheless, then he asked the facility to conduct a source test to demonstrate compliance with the limit, the 0.0015 milligram per power limit.
Yes. So the reason for this is because according to the AQMD, they did not believe that the conditions under which the source tests were done were indicative of the conditions of operation.
Okay. So there's a requirement in the rule that you have to meet the parametric conditions under which you pass the source test. So in 2018, when you pass the source test, the pressure drop, the surface tension, and so forth, those are the conditions you have to continue to meet. Is that your understanding?
Yes.
Okay. So the inspector felt that wasn't met and required a retest.
Yeah. So the source test was passed, but because of the surface tension reading being irregular, they believe that we would need to retake it.
Okay. Now there are provisions in the rule to do those measurements over a period of time without doing a retest. Do you know why the inspector went that route and said do a retest versus just continue to take measurements?
I'm not sure. I don't know.
Okay. So you did the test, and I want to bring your attention now to the permit actually that was issued, and specifically, let me pull that up, because you have specific conditions that you are not meeting on the permit, correct? excuse me, let me grab a copy of the permit. Take permit for the tank G31392 and condition number 11. It's 11. Yes, 11. Do you have a copy of that permit? And
Yes, you're talking about the line that says the hexavalent chromium emissions discharged to the atmosphere from the chromic acid anodizing tank number A10 shall not exceed 0.0015 milligrams per ampere hour.
correct. So you were informed of that exceedances November 18th, I believe, right?
I was informed of the exceedances on November 18th. Yes, that's correct.
And then you subsequently shut down the tank, and
Yes,
the facility didn't operate.
Yeah, after we gave notice to the AQMD, we shut it down.
And I think this question has been asked before. Then, when you know you didn't meet a permit condition limit, and then to continue to operate, why didn't you ask for a variance then?
Well, if we shut it down, we understood that if we shut it down, we wouldn't need a variance because we're not operating.
But when you operate, that you wouldn't need a variance, right? To continue to operate, potentially in violation, because I realize you mentioned that you've replaced the HEPAs and so forth, and I'll get to that in a bit. But your understanding was that it might be not in violation, but you wouldn't know until the test was done, correct?
Yes.
But you didn't, or you were not advised to get a variance before doing that or starting operation.
No, nobody advised us to get a variance prior to starting operation, and nobody internally here pursued getting a variance prior to starting operation.
Okay. Now, have you, looking at your permit again, have you submitted any modification to the permit? Because there are requirements to take self-essential reading and so forth, and you're no longer using those fume suppressant. Have you requested a modification of this permit?
We have requested modification with respect to the tank concentrations and the tank sizes, but regarding the surface tension, we have not requested any modifications.
Okay. Now, the test is ongoing today.
Yes, that's correct.
And you said it's a long test because the amount of chrome emitted is small, but so they have to run for a long period of time to collect a representative sample. Is that correct?
Yes, it is a test run for 3 batches of 2-hour time increments.
I'm sorry.
So ultimately, it takes 6 hours at least.
Can you repeat that because you did freeze?
Yeah.
There was a little bit of a stutter on that response, given the freezing of your screen.
So I was asked if this is a long process, if it takes a long time, and what I responded is that yes, it's done in 3 sets of 2-hour batches, and so ultimately it takes at least 6 hours. But there's also an hour of setup time, an hour of tear down time, and some breaks for the test takers. So it ends up taking a little bit over 8 hours.
Okay. Do you know when the notice date is for the hearing, for the regular or the short variance hearing? Have you got any indication when is that date?
I don't think so. I don't know right now.
Okay. All right.
It might be in my emails, but I could not tell you the date right now of when that is.
Right. So you're requesting a variance moving, it's not retroactive, it's moving forward to continue to operate until you get the results back of the test.
Yes. So,
and if the test indicates, I'm sorry, yes, that's all right, go ahead.
Yes, so the variance would cover the time that we're in operation from now until whatever date we get the source test results. So I mean, I explained in previous testimony that I was not fully aware of how it would work, and I thought that there was some amount of retroactive variance given, but I understand now that that is not the case.
Okay, understood. And if the source test fail, you'll shut down again like you did previously.
Well, if the source test fails, then the variance that we're filing for would still stand, wouldn't it? I mean, that's how I'm understanding.
Okay, okay. But
That again,
So
yeah,
but you broke up again.
So the variance that we're applying for right now, I understand that if we do fail this source test that is being taken today, that the variance would cover that time period of potentially a second failure.
okay. So let me a few questions regarding the HEPA filter. And you said Mr. Brown was from Montrose, was out there and looked at it and found there was moisture on the HEPA filter, and there was a concern. And do you? And I'm assuming you course and maybe with the aid of Montrose has done a root cause analysis. What's causing the moisture to get on the HEPA filter?
We believe that it must be coming through the mist eliminators. So the only way that moisture can get into that portion of the pollution control system is if it bypasses the mist eliminator system. And so the corrective action for that was that we did extensive maintenance on the mist eliminator system. So it was refurbished to basically the new condition.
So you didn't replace them, but you refurbished it.
Yes, so they were extensively cleaned and refurbished basically to the maximum operating condition.
And to your knowledge, did at any time do those the pre-filters, the mesh pads, exceed the delta pressure drop that is limited by the rule, by the permit condition?
No, we don't have any historical data that suggests that there was any pressure exceedance in those stages.
So in spite of the meeting the pressure drop, it looks like it's still somehow failing. Is that accurate assessment?
There had to have been some way that the moisture was getting into the chamber where the HEPAs are held. And so that's why we went to that process, because it's the one before it in line. So, I mean, there's the possibility that the moisture could be coming from the exhaust section. But we just want to make sure that everything coming into the HEPA area is operating. So, I mean, it could be, I mean, this is it could have been something else, but we don't have reason to believe that it was something else.
So what corrective actions are you taking to make sure that it doesn't happen again, even if you pass the source test? Because
we've increased the frequency of the visual inspections for the mesh pads. And we've also connected the outlet for all of the liquid that comes off of the mesh pads to go back into the tank, whereas before it was being collected in a different vessel.
I just want to make sure we're not going past good cause.
right, yeah, yes, I think I did the last question, so I'll stop there. I got them for the question.
Okay, thank you. Board members, additional questions for Mr. Alonso? Senator, questions?
So, Mr. Alonso, how are you? Look at on page exhibit, which I don't have the number written. It's called the coast plating anodizing operation. It's a flow chart, flow diagram. Are you familiar with the flow diagram?
And just to be clear for the record, that is Exhibit 1, the attachment, the first attachment to the emergency variance petition.
Thank you.
Yes, I have that in front of me.
What's the purpose of this flow diagram? Does it show the filter? Does it show the system of operation?
This simply shows the chrome anodizing process, so the wet line process. This does not show the pollution prevention control system.
Does not show the components.
No, it does not show the components of the pollution prevention control system.
So the purpose for you presenting this flow diagram is what?
This was to show that the chrome anodizing was an integral part of the process, and that without the chrome anodizing, we can't complete the process in its entirety. And so all of the other activities done on parts would be affected, and then we wouldn't be able to finish the products.
Are you the program manager or the project manager of this project?
What was that?
Are you the program manager or project manager of this project?
No, I would not say that I am. That would be my superior.
To your knowledge, is there a program manager or project manager on this project? You just been there a short time.
Yeah, the vice president of environmental health and safety is overseeing all of the environmental projects, and I'm just the point person at the site because he's not actually physically here.
Would it be your opinion that some of the questions asked of you that you couldn't answer, that the project or program manager could answer?
Yes, I think that if you were to ask my superior, Corey McGraw, he would be able to answer the questions that I was not able to answer today.
I think the question is to Mr. Cohen. Well, we don't have him, but you're here now.
He was out of town and couldn't be here, so he wasn't able to participate. He had something else, and so we wanted to proceed with the date. We didn't want to lose the date. So, yeah, and Adam has been involved in the process.
The data is very important to you and to the company, obviously. Now, this project, this whole system, do you have a program for troubleshooting the system?
We have an operations and maintenance plan that applies to it.
So how do you determine the failure rate of the filter?
Well, the filters are tested individually by the manufacturer. So when they get the 99.999 or 99.997 rating, that rating comes from the manufacturer, and they test them individually before they send them to us. So they're not allowed to say that it has a certain efficiency without first testing it and certifying it.
In your opinion, if you know, what's the life expectancy of the filter if you need to have so many on hand?
Well, the life expectancy of a typical HEPA filter would be 12 to 18 months. And so these are changed annually here.
They change annually. Okay, what's the function of the mist eliminator?
The function of the mist eliminator is to prevent moisture from getting on the HEPAs. So to prevent the exact conditions that we see here.
Could that be the failure? Could that be the cause of the failure of mist being deposited on the filter?
Well, it could have been the cause of the failure. And then, I personally feel that the issue was addressed as well when we refurbished them. So if that had been the cause, it's also been corrected now.
Well, if it were the cause then, the next source test, it could be the cause again. If you don't correct if that's, could be a problem. Did you check it out to determine whether or not there's a problem with the mist eliminator?
Yeah, we have checked it. The maintenance team has checked it, and there's no indication that there's anything wrong with it at this time.
How did the moisture get deposited on the filter? The function of mist eliminator is to make sure that didn't happen. Yeah,
something must have happened in the process where
Obviously.
the mist eliminator system was overwhelmed with moisture. It has a 95% efficiency at each of the stages. So it could have been a cumulative thing. It could have been a one-time thing. I couldn't tell you specifically what the failure rate was.
So I guess we can only hope today it would work out just fine for you. Let's look at some of the dates we have here now. On October 12th, Montrose Services perform a source test on the system, correct?
Yes, that's correct.
And they didn't say that it failed. On October 24th, they conducted an inspection and found evidence of moisture on the system. Then on November 18th, they state that verbally informed Valence that the source test had failed based on the analysis of the source test results. And this observation of the HEPA filter that was conducted by Montrose. On November 23rd, the facility received confirmation the new HEPA filter would be delivered on December the 8th. Well, then you know on December the 8th that you had to apply for a variance if you were to get this thing installed and back in operation.
No, I did not realize that we would need to apply for variance until we were contacted. So we were contacted on December 11th by Frederick Chung of the AQMD, who told us that we couldn't operate yet. And then on the 16th of December, I found out that we would need to apply for a variance.
When you were in operation, were you operating with the consent of the variance?
Wait, I don't understand the question. What was?
When you were operating successfully, did you have a variance? Yes or no?
Were we operating successfully to get a variance?
Do you have a variance to operate?
Well, no, we don't have a variance to operate right now.
You have a permit to operate is my question, I'm sorry.
We currently do not have a variance to operate.
You knew you had a permit to operate, yes or no?
Yeah, we know we have a permit to operate, yes.
And then when it was determined in November that you're not in compliance, and you knew in compliance you're not operating, you were operating outside of the permit condition.
We were not operating from November 18th through December 11th.
I understand. So in November 23rd, you received confirmation the new HEPA filter would be delivered on December the 8th. And you had no idea at that time you needed a variance in order to install it.
No, I did not know that at the time, no.
You think the guy above you, the general manager, might have known?
Well, the conversations that we were having with Montrose did not make me think that we needed a permit for variance. I mean, it goes back to one of the board members asked me earlier if we looked it up, if we contacted the AQMD for guidance, and I mean, it goes back to that question of we were of an opinion that was the same opinion as Montrose, and so we didn't pursue any further questioning. Or
on December the 9th and 10th, the facility replaced the HEPA filter with the new identical HEPA filter, tested the new filter on December 11th by, among other things, checking the pressure differential to make sure it was operating correctly. At any other time when you was determined you had a failure, were you checking the pressure at that time differential?
Yes, during the time of the source test on October 12th when we failed, we also checked the differential pressure And that's included in the source test report.
So it's only a guesstimation that based on December 5, 9, and 10, that it would operate successfully. You didn't know for sure that it would. You won't know until today. Is that correct?
We would not know for sure whether we're in compliance or not until we get the results from today's source test.
Days test. All right. The dates show me at least that you had ample notice or should have known, but you didn't know because you didn't understand the procedure, I guess, the process, that you would not be in compliance. You needed a variance, you had to apply for it. That's all.
Okay, so I'm sorry, I just want to be clear. So you just said you don't know if you're going to be in compliance until you get the source test results back. Is that correct?
Well, we can't know for sure. We're operating right now with the assumption, well, we're doing the source test right now with the assumption that everything is going to be passing.
Okay, but you're admitting that you don't know, because you don't know until you have a source test result. Isn't that correct?
Yes, and I mean, I guess that goes back to why we're applying for variance.
Okay,
Firstly.
I want to go back to that because you threw something new into it. According to the papers, again, the theory of the case, again, what you presented today is that you'd never applied for a variance and you were going to start operating because you thought you were in compliance just by replacing a HEPA filter. But now today you've said your hope is that this variance that you're requesting today would go through a second failure should that happen and protect you through a second failure. Why do you need to ask for that?
Well, I personally don't think that we're going to fail today. I have not been, like, me alone, it was not my decision to apply for a variance in the first place. I mean, I'm appearing here as a witness for you, but I don't actually make the decision of whether we're going to operate or not.
Okay, so
I'm just relaying information.
why does Coast Plating think?
What was that?
Why does Coast Plating think that you need variance protection through a second test in the event you should fail it?
Well, they want to have their bases covered. Well, Coast Plating wants to, in the event it should fail, they want to be able to continue operating. But it's not our position that we're going to fail. Like, in our belief, we won't be failing today.
Okay.
And I mean, part of this whole variance process is kind of to rectify the past mistake of not. I mean, it doesn't retroactively apply. I understand that now, but I mean, it kind of is a show of good faith to apply for it now, I would say.
I want to be clear. The reason why it doesn't retroactively apply is because the hearing board wants petitioners to come as soon as they think they might possibly need it so that we don't have to jump over public notice. That's why we're in the good cause phase of this hearing. So that's why we ask to come. That's why we don't give retroactive relief. You should come as soon as you know, or should know, that you more likely than not might need some relief. So I just want to be very clear on the reason why we apply these standards. They're not, they make sense. Any other questions before we move on? Senator?
Right, Exhibit 1, we've discussed briefly, but is there any reason why you didn't have a flow diagram for the operation of the system with a mist eliminator and with the filter showing the components of this whole process?
The permit outlines the process, so we didn't think we needed to have redundant information in there. If you look at the permit, it calls out the 3 stages of mist eliminator and then the spec for the HEPAs that's required.
Just to be clear, I just wanted to say that because we want to see diligence in filing, we say in our rules and in our examples of our rules, further discussion of our rules, we say petitioner is only required to present the information that it has gathered by the date of the emergency or interim variance, and we don't expect that they're going to have all that information. It would be helpful for sure, but we want them to get in as quickly as possible.
It also states in requesting information that you provide all diagrams, all somewhere, drawing, whatever, anything that would explain the position that you're going to take. And I don't have a list in front of me, but
Yes.
it does have the diagram.
It is in the petition and it is favored by the board 100%. I just want to be clear that we want parties to come in as quickly as possible. And so if they're going to be delayed coming in quickly because they have to make diagrams, it's better they come in quickly. Although by today, a diagram would have been helpful. I
And
agree.
they took time and effort to provide Exhibit 1, the floor diagram, which is meaningless in my view, as far as what we're trying to determine today. This diagram doesn't show any reason why a component should fail. If you had a diagram of the components, they can discuss to the board, to each and every one of us, where the failure might have occurred. And so when they troubleshoot the system, and then they can say, well, here's where we had the problem. The missed eliminator just having to come up in discussion. That's a major component of this system operation. And you have a diagram that will show that. And otherwise you have to read it very carefully and closely to determine that is or may be part of the component and may be contributing to the failure. You know, all right,
I agree with you 100%. Are there any other questions for Mr. Alonso before we move forward?
I have some follow-up questions when we.
Yes, Mr. Cohen, this would be a good time for follow-up questions.
Adam, there were some questions about the rule and understanding the rule and what was required. After you found out that that you failed the source test, did you look at the rules to determine what the appropriate course of action was?
Yes, we reviewed the rules, and in the rule 1469, there's guidance on what to do in the event of an exceedance. And we followed the bullet points in that section, you know, the giving notice and it within a timely manner, and all the other components of what's required in giving notice. So what our planned corrective action was and what the excess emissions were, that was all noted in the submittal.
Right, so just to clarify, you looked at Rule 1469 P4B, correct?
P, it's 1469 P that deals with the source tests and the notifications. So that's the section that we were looking at when we called it in, and then when we emailed the board.
Right. So, and that has procedures that you should go through if you have an incident, correct?
Yes, and those are the procedures that we followed.
Okay, and there's nothing in Rule 1469 P4B that says you have to do a new source test if you have an incident, is there?
No, in 1469 P4B, which is the section that we were abiding by, there was no requirement in that section listed for a new source test or a timeline for getting one.
So you understand now that the district's position is because of a footnote in another table, you have to have a source test. But at the time, you didn't understand. You had looked at the rules and didn't understand that that's what the district's position is. Correct?
Yes, that's correct. And I mean, I've learned information here just in the process of this hearing that I did not know before. So yes, that's correct.
All right. Now, with regard to emissions, the 2008 source test, I think Ed's going to testify more about this, but do you know how much below the limit the company was in 2018?
Well, the 2018 source test was far below the limit. I think it was less than half, even less than a fourth. And I have that. I mean, I could pull it up. I have the source test available to me, but it was extremely low, and because of that source test, that's just what we believe the emissions to be from that point forward.
Right, and you weren't using suppressants in 2018, correct?
We were not using chemical fume suppressants in 2018.
So with regard at least to the use of suppressants, you did not believe in 2018 that the change in surface tension would have a significant impact on emissions. Is that right?
Well, based on the operating conditions, and we believe that the operating conditions now are the same as the operating conditions in 2018. The surface tension has not changed. Well, I mean, the surface tension has a reason to have changed because we don't have any difference in the chemical composition of tanks, and so we assume that the test results would be the same from October 12th as they were in 2018.
Right. Okay. But those turned out not to be, and that was evaluated by Montrose, and they determined that they believe it's the HEPA filter problem, correct? That caused that.
We have had conversations with Montrose, and we believe that it is purely because of the HEPAs having moisture that this exceedance occurred.
Okay. Now, there was a question about what you did with regard to the moisture eliminator. Is it correct that you did refurbish that?
Yes, that's correct. We've replumbed it as well. So part of the process is cleaning it all off, restoring the material that it's made of, and cleaning the vessel that it's housed in, and then replumbing all of the water lines that come out of it.
So you did take steps you did take affirmative steps to try to make sure that there's no moisture problem going forward, correct?
Yes, that's correct.
Now, okay, I think that's all the questions I have right now.
Any other questions before we move on? Mr. Bolivar?
Just a quick follow-up, Mr. Alonso. You said you had the source test, 2018 source test in front of you, or you can look it up?
Yes.
Do you know what the surface tension readings were during the source test?
Let me scroll through here. Surface tension was 48.1 for the first, and that's dynes per centimeter. It was 48.1 for the first run, 47.2 for the second run, and 45.2 for the third run.
So what was it in 2020?
In 2020, it was 71.6 for the first run, 72.0 for the second run, and 70.6 for the third run.
Okay, so they were substantially higher than what was established as a parameter during the source test that demonstrated compliance with the limit.
Yes, it was higher than the compliant source test. That's correct.
Okay. All right, thank you.
Any other questions, Senator?
Right, and on item number 7 in the petition, describes a request, or briefly describe the activity or equipment and why it is necessary to the operation of your business. Schematics or diagrams may be attached. You did attach the flow diagram, You describe the operation of the flow diagram. But the most significant part of your operation and whether or not it's going to fail or succeed is the mist eliminator and the filter, which was not discussed in response to the question number 7. So that's the reason why I raised that question. You have a clear and understanding.
I 100% agree with you that that is something that is very helpful to this board. The only thing I was pointing out is that we don't want petitioners to get hung up on having everything, and we don't require that so that they can get in quickly, because right now we're looking to see if they were actually diligent in filing. But I'm not disputing that that is super important and helpful. Ms. Honey-Zavra, you had more questions?
Just a couple more questions to kind of bring it back to the issue of diligence for good cause, and kind of re-ask a couple of questions now that we've had more testimony. So actually just one question, I guess. After the source test this past fall failed, are you now at least of the understanding that to operate in the absence of a compliant source test, you would be in violation?
Yes, I do understand that now, yes.
Okay, that's all I have.
Okay, there are no other questions for Mr. Alonso. Thank you very much, Mr. Alonso, for your testimony. Mr. Cohen, do you have another witness that you wish to present for good cause? Again, for diligence in filing, for, it's very similar to beyond reasonable control, but even more stringent, which is could not reasonably have avoided the violation, and any other information you need for those 4 findings that were outlined.
Yes, I'd like to call Edward Chris Snoddy of Montrose.
Yeah, I'm here.
Edward, could you spell your name for the record?
EDWARD KRISNADI.
And do you have, did you take the oath?
Yes, I did.
Okay. Could you tell me where you're employed?
Montrose Environmental.
And what does Montrose do?
Montrose does a lot of environmental work, variety of environmental work, from source testing, remediation, permitting and compliance, and water, air, and soil media. So multiple variety of environmental work.
It'd be better if you could speak up a little. I'm having a little trouble.
Oh, sorry.
hearing.
Montrose does a lot of environmental works, from air, water, soil, media, from permitting, compliance, source testing, remediation, a lot of different spectrum of environmental works. Is that better?
A little better. What do you do for, can you tell me what your educational background is?
My educational background is chemical engineer. That's my educational background.
And what's your work background?
I've been an air quality consultant for over 18 years, involving in, part of my early career is in the emission inventory side of the program. But since I joined Montrose, I've been involved in the permitting and compliance program.
Okay. It might be speak a little slower also. Might be helpful. Thanks. Now, can you tell me what Montrose does for coast plating?
What Montrose does for coast plating is source testing and permitting and compliance works. For me personally, I mostly involved in the permitting and compliance program side of it. I worked with coast plating, I think in summer 2019, so a little bit, less than 2 years, when I prepare a variety of permit applications for the facility.
Edward, do you by any chance have a flow diagram handy?
A flow diagram?
A diagram of the emission control system.
I don't, but I believe they actually have it on the source test report itself.
Unless you could disseminate it to the board, that would not be.
Okay, well, the board, if that's the case, the board has it because it was that was submitted. We can I can get it, pull it up, but it was submitted submitted by the district yesterday. So I try to pull that up.
I don't think we have it though.
No, you're sorry, Mr. Cohen, are you referring to the 2 source tests that were submitted last night?
Yes.
Yeah, they weren't distributed because I
Okay. Can we if we can find it, can we screen share it?
I can let me send it to the clerk right now just to wait 1 second. Okay.
Well, Teresa, do you know how to screen share? If you
I don't have that capability with the computer that I'm using. What I can do is once she sends it to the clerk of board, I can have her send it directly to you, Julie.
send it to Mohan because my computer is not.
Yeah, I can do it once you send it.
Okay, I'll have her send it to the board members, and then Mohan, you can take it from there. Okay.
Let's not get hung up on it. Let's move forward with the good cause findings, please. While we have that sent.
It's sending, but for some reason it's taking a minute. So hopefully it should be soon. Sorry.
Did Montrose arrange for a source test in October for post plating?
Yes, we did.
And why did it do that?
Because it was the source test was requested by the AQMD engineer, permitting engineer, Caleb Phillips, I believe that's his name. And the reason he's requesting for the source test in October, because the surface tension value has been changed, or it's different than what it was done back in 2018 source test.
And how did he know that the surface tension had changed?
Because he requested the surface tension reading for several months. I believe he requested for the month of March, April, and Coast Plating provided those surface tension reading to him.
Now, can you explain why as a general matter, the district is concerned about what the surface tension is?
Well, the surface tension basically is a property of the surface liquid that prevent spreading the liquid on the surface film phase. So in general, in terms of how is it related to emissions, the higher of the surface tension value, the easier for the vapor in the liquid to go through the surface film, because the liquid is not as gelled, if you will. The liquid is more spreading. So as a result, a vapor or gas will be easier to go through the surface film and therefore release to the atmosphere. The lower the surface tension, it will make the vapor more difficult to go through the surface film and therefore go to the atmosphere. And chemical suppressant, it's one of the ways that facility use to lower the surface tension values.
But as far as you know, Coast Plating has not used any suppressants in several years, correct?
That's correct.
Now, did you look at the 2018?
I cannot hear your.
Have you looked at the 2000? Sorry. Have you looked at the 2018 source test?
Did I look at the 2018 source test?
Yes.
Yes.
Did you review how far below the limit the equipment was in 2018?
You mean the result of the emission?
The result, correct.
Yes, I look at it. It's about, I believe, it's 22 times lower than what the emission emission concentration standard, which is the 0.0015.
So it was more than an order of magnitude lower, correct?
That's correct.
Okay, and did you have any reason to believe that the change in surface tension would increase the emissions by over 20 times?
I don't have, I do understand that I cannot say 100% until a source test result showing it, which is what was done today. But based on my experience, I do not believe that, yes.
So you, so when they resumed operations, your understanding, you believe that they would be in compliance because the equipment was doing much more to control the emissions than was absolutely necessary to meet the limit, correct?
That's correct.
No. Now, on October 24th, the inspector, I guess the project manager came out and looked at the equipment. Can you tell me what he observed with regard to the HEPA filter?
He observed an evidence of moisture from the HEPA filter.
Okay, but did he observe any anything that showed that the HEPA filters were not working properly at that time?
At his inspection during that time, at the visual inspection?
Yes, right.
He observed there are evidence of moisture on the HEPA filter. And I think that's leading that there's some, the HEPA filter has a defect on it.
Right, but did he know that at that time? Did he know that the source test would fail?
He did not.
No, and did he know that the moisture in the HEPA filter was what could cause it to fail?
He cannot know for 100%. No.
Okay, and ultimately, after he received the results from the source test, did he look at that data to try to determine what the cause of the failure was?
Yes, he did.
And what did he determine was the likely cause of the failure?
It will be the HEPA filter defect.
Right, and those are the HEPA filters that were replaced on December 10th, correct?
That's correct.
And so you had reasonable reason to believe that when they resumed operations on December 11th, they would be in compliance with the permit, correct?
That's correct.
Right.
If I may interrupt, Madam Chair, I can, if you want to give me screen share, I can bring it up if you need it, Mr. Cohen, to.
Why don't we wait until you, Mr. Cohen, are your questions going to reflect that? Are you ready for that? Or do you want to continue with your questions and then tell us when to share the screen?
Well, actually, it might be good if you could bring it up because that would allow Edward to describe the system, which I think would be helpful to everybody.
Okay, can I make you a co-host? I think I can.
I need to, Madam Chair. Who needs to be a co-host?
Mohan.
Okay, I'll do it right now. Let's see.
Thank you, Paul.
You got it. All set to go, sir.
All right. Can you see the screen?
No.
No, not yet.
Not yet. Oh, okay.
Now we can.
Okay.
Perfect.
Okay,
Great.
so Edward, can you explain what this diagram shows?
Well, this is I think in the diagram in the 2018 source test. So it shows the components of the air pollution control system. On the left, you'll see that anodizing tank, which is where that emission is being created, and you see the hood where the emissions being vented to exhaust, and that exhaust is pretty much venting it, goes from the shop floor, goes all the way to the rooftop. On the rooftop, it vented to the air pollution control system, which contain of that mist eliminator with mesh pads, and then it goes through a pre-filter, and the last stage of that control system will be the HEPA filter.
And how many HEPA filters are there?
9. It'll be a configuration of 3x3.
And when the moisture was observed, was it observed in all of the HEPA filters or in one area of one HEPA filter?
Based on my conversation with Stanley Hugh Brown, who the one that did the visual inspection, he observed on one HEPA filter.
Okay, so the other 9 HEPA filters were didn't have a moisture problem as far as you could tell, correct?
To my knowledge, yes.
Yep. Okay. And then, okay. So I guess I know people had, well, we can ask afterwards, but I hope this helps clarify for those people that might not have understood the flow. This was how the system operated.
So that we can see everyone at this time, maybe stop the share.
Okay.
Thank you. Thank you so much, Mr. Balagopalan.
Yeah, thank you very much. I appreciate it. Now, what was your understanding of when Coast could resume operations?
At that time, my understanding, Coast could resume operation when the HEPA filter was replaced.
And why did you think that?
Because the HEPA filter is the root cause of the failure of the source test. So once the HEPA filter is being replaced, my understanding is that the facility will be in compliance.
And did you convey that to Montrose?
You mean the Coast
I mean,
plating?
did Montrose convey that to Coast Plating?
We did.
On December 11th, there was a question. I guess the district inspector said that you couldn't operate until you had a new source. Coast couldn't operate until it had a new source test, correct?
That's correct.
And did you have a discussion with Mr. Chung at that time?
I did. I had a phone call follow-up with Mr. Frederick Chung to discuss about the matter because we still because it's against with my understanding, and because there's in agreement about the district view in this matter, I requested a conference call with him. And I want to correct it. The conference call is on Tuesday, December 15, I believe. Then we had a conference call with his senior and supervisor to confirm about this matter.
Now, are you aware of any times when a system is allowed to operate before it has a compliant source test?
Yes, and part of my conclusion of that view is coming from that as well. When a facility install a new air pollution control system, the source test would not be required in the day one. The facility will have typically 90 days before they could conduct its source test. And even when the source test conducted and being reviewed or being analyzed by AQMD, the facility could still resume operation.
Right. So there are. It's not. In fact, it's not uncommon for a facility to be able to operate before it has a source test showing compliance. Is that right?
That's correct.
And that was part of why you believe that since the system had been restored to its original condition, that there was no need to do another source test. Is that right? I mean, there was that they could operate before doing the source test.
That's correct.
Now, based on your understanding, was the engineering, was that system based on what you know about what the emissions were at the source test on October 12th? And the design of the system, did you believe that the system was capable of controlling the emissions from the tank?
I believe so, based on my experience. This type of air pollution control system is designed to meet the emission standard or of 0.0015 without any help of the chemical fume suppressant. That's based on my job experience. Now, again, I want to preface my question. I understand that the facility has the responsibility to do a source test to demonstrate that compliance. But based on my job experience and other facility, plating facility, this type of air pollution control system is used, and in the operation where chemical suppressant it's not required to be used, and they able to meet the emission standard.
Right. So you believe that is essentially because that using the 2018 source test and your knowledge with regard to this kind of equipment, that the system was meeting would comply with the standard. Is that right?
That's correct.
Okay. And so okay, sorry. Now, with regard to when the source test should be done, when did you at what point in the process did you recommend that the source test be done? The new source test?
Oh, as soon as the filter is being replaced and being tested in terms of the filter is working appropriately or effectively according to the manufacturer, then we recommend the source test to be done as soon as possible.
And to your knowledge, did Coast schedule a date as soon as possible once they knew when the filters were installed?
That's correct.
And did you scheduled it, and the earliest date was January 7th, correct?
That's correct.
And did you try to find any earlier dates?
We did. We tried, but due to the holiday schedule and other priority that our source testing technician already had, January 7th was the earliest one that we could do.
Now, did you make a determination as to what the daily emissions were when the system was operating over the last few months?
Did I calculate it, you said?
Yes.
I'm sorry. Yes, I did. And I think I presented in Exhibit 3.
And could you explain what you...
I'm just going to ask, is this relevant to the findings for good cause? Because usually excess emissions.
Well,
for the
one of the... Sorry, you got cut off.
Again, diligence in filing, again, reasonably avoiding the circumstances that led to the violation, and harm to petitioner. Those are things. I don't know about excess emissions, if that's relevant at this point. And if
but it does go to the question of whether there was reason to think that they wouldn't be in compliance.
That's not the question. I think the question is whether you knew that legally under the rules you were required to have that source test before you started up again. Not whether you thought you'd be in compliance with the emission limits or anything like that. That isn't what's relevant here.
Well, I believe it is relevant because, again, as I think the witness just pointed out, there are many instances when equipment is permitted to operate before it has a passing source test.
Sorry, I'm going to just cut you off because either you're in compliance with Rule 1469 or you're not. Bringing in compliance in other situations is not relevant, and either you're out of compliance and you should have known that you were because you don't have a source test yet, or not. There's no. Amount of emissions is not relevant at this point.
Then I have no further questions at this point.
No further questions at this time. Okay. Ms. Zanizabra, do you have questions?
I have a few questions for Mr. Krishnadi. So Let me start with some clarification. At one point, I believe you mentioned that you were sure that the HEPA filter led to the failure, but then wasn't clear if you were 100% sure or if you would be sure once the source test eventually passed. Can you kind of elaborate on why you think to what degree of certainty do you believe the HEPA filter was the cause of the problem?
I cannot give a number in terms of degree of certainty of it, but based on my experience, I do understand the belief that once the HEPA filter is being replaced, even at that time, I do believe that once the HEPA filter is replaced, then the facility will be in compliance. I do recognize and understand the rule require the facility to demonstrate source testing to showing that, but I was not aware that the facility cannot resume operation once the filter is being replaced.
So I don't want to focus too much on surface tension or get off track, but I will ask, under the current operating conditions with the surface tension as it stands now, do you agree that the most recent source test failed?
I'm sorry, can you repeat that again?
Okay, did the most recent source test fail?
Correct.
Yes.
Yes.
Correct. Okay, and when did you become aware that it could possibly fail, could potentially fail? Around what date?
Potentially fail?
When did you become aware that the source test may not pass their source test?
I personally know on the November 18th when Montrose verbally notified the close plating.
Okay. And so there was a little bit of talk about operating without a source test, and I believe the focus there was initial source tests. But are you aware of a time when a facility can operate after receiving a failed source test result?
No, I'm not aware.
I think that's it for now.
Thank you. I just wanted to follow up on the first question that Ms. Honeyzauber just asked. Well, maybe it wasn't the first, but anyway, to follow up on one of the questions. Earlier, it was testified to that Montrose reported sometime right after the October 12th source test, irregularities. Were you aware of that?
I personally wasn't aware of that, but I do know Montrose aware of that. Mr. Stanley Hugh Brown find that irregularities. That's why he went to the facility on October 24th.
Okay, so that was my next question. So it was due to the irregularities, to your understanding, that Montrose went back and then found that there was moisture on the HEPA filter.
That's correct.
Okay. And then you just testified a little bit ago that you could not know for 100% that a HEPA filter with excess moisture like that would result in excess emissions of hexavalent chromium. But did you know at that time, or did whoever went and looked at the condition of the HEPA filter at that time on October 24th, that it was likely or quite possible that that could be causing excess hexavalent chromium emissions?
I would say Mr. Brown quite possible have that, but he also cannot say 100% for sure because he has to finish all his engineering evaluation, including had a complete lab data. The reason he visited the facility was he got a preliminary lab data that's showing irregularities, but obviously he has to go through his QA/QC and other process to finalize.
Okay, it needs to be finalized, but was there some degree of of understanding that it was likely? What was the likelihood that you thought at that point, Montrose, not you in particular, that it was likely that this was not going to be a passing? I mean, we don't want to wait till finality, so I'm trying to understand where.
Right. I cannot answer to that question. I would have to find out from Mr. Brown himself what on his opinion on that.
But you knew for sure by November 18th.
That's correct.
I just had one other question. How do you know? Can you today know with certainty, given what you testified to about the differences in surface tension, and the higher the surface tension, the more likely it is that vapors can escape to atmosphere? How do you feel confident that it was only the HEPA filter and not the surface tension that caused the exceedance, and that there will be a passing retest?
Without getting the test result?
Without getting the test results.
I have a pretty high confidence in it because I do know that HEPA filter has much higher control efficiency than chemical suppressant, which is affecting the surface tension. As a matter of fact, that's the reason AQMD has HEPA filter system as part of their best available control technology. And in a lot of cases, the surface tension discussion was brought up when a facility using chemical suppressant. If a facility is not using chemical suppressant, I believe that HEPA filter system is the best available control technology.
Okay, but and so you feel pretty confident that it's going to pass?
I am.
Okay.
But again, I don't know 100%, of course, without the source test result.
My source test results are important. Board members, additional questions? Mr. Balagopal.
Thank you. Mr. Krishnadi, I think part of the requirement during the source test is to take the reading of the pressure. I mean, not the surface tension, correct?
That's correct.
And if they pass, whatever the reading is, that's the parameter that they pass under the condition that they pass the source test, and they have to meet that subsequently.
That's correct.
That's correct. Okay. So your advice to a facility that has a permit to operate, which is the situation here, and they are conducting a retest because they need to do a follow-up test, and they fail a source test, they can correct whatever this assumption is that led to the failure and continue operating without getting a variance?
At that time, that was my understanding.
And has it changed now?
Yes.
Okay.
After the conversation with the district and on December 15, we understand the district position. So yes.
Now they actually cited a different section of the rule that you needed, why you needed a variance, but and I think it was P4B or something like that. But it's also because of you failed the emission limit that is in 1469, and which is also part of the permit condition.
So I'm sorry, what's the?
So the reason for getting a variance is because you failed the 0.0015 milligram per amp hour, correct?
Right, because we failed the source test meeting that, correct.
That limit. Okay. All right. Thank you.
Any other questions, board members? Ms. Verdugo-Peralta, and then Senator Holton.
Thank you, Madam Chair. Mr. Krishnadi, are you the only Montrose employee that provided information to Coast Plating on this project?
No.
Okay. How many others provided the information?
So there is Mr. Joe Rubio, which is the source testing technician, which is doing the testing as we speak right now, and Mr. Hugh Brown, which is the project manager.
Okay, so was it you or was it the project manager that basically gave them the information of that they did not need to contact the AQMD and or that they did not need to question any further regarding whether it was source testing or going forward, that they would be in compliance.
Mr. Hubran, the one that emailed the close plating, that the facility will be in compliance. He did not say that close plating did not have to contact AQMD. He just mainly stating that, in his opinion, that the AQMD, I mean the facility is in compliance when the filter is replaced.
Okay, and in reference to that information, how long have you been dealing with permitting and compliance, whether it's with this company and or other companies?
Specifically for permitting and compliance, 7 years, over 7 years.
Okay, and in your experience during that 7 years, have you come into a situation where you needed to contact AQMD regarding whether you were not clear on a rule or not?
Oh, absolutely, yes.
Okay, so you've had no qualms about contacting them and clarifying information?
Not at all.
Right. However, but in this instance, you didn't feel that there was a necessity to do so. Is that correct?
Because I felt, at that time, I felt that my decision is correct. Our view is correct. So that's why we didn't contact the AQMD.
Okay. That's all I needed at this time. Thank you.
Thank you. Senator, you have a question.
Mr. Krishnadi, on October 24th, Montrose conducted an inspection and found some evidence of failure. Were you aware of that report?
I wasn't at that time or right now. I'm aware of that report right now, yes.
You are aware of the report?
Yeah.
Is it in writing?
I'll back up a bit. I'm not too sure if there's a report or it's just more of verbal conversation.
Just give me this straight now. With a report,
I'm not aware of if there's a report.
Written report. Then how did you become aware of the fact that they did a report?
I'm not aware of any written report, but I discussed with my project engineer who went to the inspection that he find this incident.
So to your knowledge, there is no written report?
Correct. I'm not aware of any written report.
Thank you.
Any other questions before we move forward? Okay, thank you very much, Mr. Krishnadi. Mr. Cohen, did you have any other evidence or witnesses you wish to present on good cause?
No, we don't have any other witnesses.
Thank you, Mr. Cohen. Ms. Hanizabra, sorry, Ms. Hanizabra, did you wish to present any witnesses on good cause?
I don't have, I have district witnesses present and available to testify on good cause. I have Mitch Heimov, a senior air quality engineering manager, and Fred Chung, an air quality inspector. But I do not plan to bring any affirmative testimony during this phase for good cause.
Board members, anyone need to hear from a district witness to make the 4 findings for good cause? Okay, thank you. And thank you, Ms. Hanizabra, for making that available. Okay, so at this time, then I'm going to ask Mr. Cohen if you would like to give a closing on good cause and the findings we need for good cause.
Yes, thank you. I know that there have been a lot of questions raised today about the activities and the timing and the sequence and how fast they went. But I do think that the record shows that based on what they believed, what Coast Plating believed and understood, the rules to require, that they did do what they thought was correct and they did it expeditiously. And I note, for example, that when they found out on October 24th that there was a potential problem with the HEPA filters. And at that time, no one said that the source test might fail because of that. They immediately ordered new filters. And when they found out that on November 18th, verbally, that they failed the source test, they immediately stopped operations. And they attempted to get the new equipment and get it installed as fast as possible. And when they found out that under the district's interpretation of the rule, they were required to get a variance, they immediately applied for a variance. Now, I understand now that it's pretty clear that they had a different and their consultant had a different interpretation of the rules. And I don't fault the district for its interpretation. I understand it, and I'm sure in the future the company understands it. But I don't think it was in bad faith. I don't think their belief in how to interpret the rule was in bad faith. And because of that, at least in their minds, they were acting as quickly and as expeditiously as possible to deal with this problem. And they acted as expeditiously as possible in seeking the variance. I guess that's basically the point I want to make. I mean, I understand, the rules are complicated. They're difficult. They did look at the rules. According to the district, they misinterpreted the rule. I understand that. But that doesn't mean that they didn't have a good faith belief that they did was correct. I think they've demonstrated that they had a good faith demonstration that it was correct. And therefore, I believe that they have made the requisite they've proved that they did, that it was not reasonable. They did what was reasonable, and there was no reasonable way to actually shorten the time based on their understanding.
Thank you, Mr. Cohen. Ms. Honey-Zabra, you're closing on good cause.
Good afternoon, once again, Chairwoman Prusak and members of the board. Based on the testimony we've heard, it's still the district's belief that the facility was on notice of the rule requirements, and in particular, the emission limits set forth in 1469, and the fact that they needed to be demonstrated by a passing source test. The testimony, we believe, has also shown that although they had a good feeling or a high level of confidence, they could not be 100% sure what the root cause of the source test failure was, but did assume that they could continue to operate so long as they replaced the HEPA filter. But unfortunately, this assumption was false, and there ended up being a 1-month gap between knowing that the source test would most likely fail and then beginning the process of seeking coverage. So the district does oppose a finding of good cause.
Thank you, Ms. Honey-Zabra. I'm going to turn it over to board members to begin deliberation on good cause and the 4 good cause findings. Just to put it in perspective again, before we begin that conversation, this is to determine whether we have good cause to proceed to a hearing on the merits in absence of notice to the public. So that's what this discussion is about. Would anyone like to begin the discussion? Senator Holden.
At the opening of the discussion on this issue, Madam Chair, you mentioned that would have known or should have known that they had to apply for variance. It's been clearly stated in the evidence that they knew, but then they didn't. They knew there was going to be a failure, and that being the case, they should have applied in the appropriate time, which I don't think they did. The thing that sits forth in the argument opposing to their request is in their petition. The various dates they give and the function of operation at that point in time on these various dates, which they didn't have to have more than a clue that they would not be in violation and they should apply for variance. But in fact, they were in violation and therefore should have applied for variance. Not knowing, as you stated, knowing or unknown, doesn't grant them the privilege to gain a variance at this time. So my position is that I support the district's position not to grant a variance.
Thank you. I want to read again. Let's read again, because I agree with what you're saying, Senator. And again, what we're talking about is exercising diligence in petitioning for an emergency variance. And it shall mean that petitioner filed a variance petition as soon as feasible after the time petitioner knew or should have known that a variance would more likely than not be needed. And petitioners are urged to file a petition upon acquiring preliminary evidence of a likely violation, rather than waiting for absolute certain evidence of violation. So let's talk about the various dates. First of all, there is the idea that early on, right after the source test was first done, that there were irregularities noted. Now, that doesn't necessarily mean that it was more likely or not than not that they would have needed variance coverage at that point. But then on the 24th, there was enough irregularities to cause Montrose to come back to visually inspect and see what could be wrong here. And so I think that the probability was probably on the upper scale at that point. And they did find with certainty that there was a HEPA filter on October 24th that had excessive moisture. Yet they continued to operate because it was such a long time lag between getting a new HEPA filter. That was an issue, I think. However, okay, they didn't get the failed test until November 18th. That would have been a good time to seek variance relief while they attempted to get back on track, get that HEPA filter in there, and retest. They didn't do that. And I know that there was testimony with regard to a month or more to get before this board for a noticed hearing, but that is not the case. When you only need a short variance, which lasts less than 90 days or less, it only takes 15 to 21 days to complete that and have a hearing. So certainly we would have had a hearing by now and well before now, and it would have been noticed. And again, really, we're only talking about whether a noticed hearing. I'm not even talking about the merits of the matter here. But then let's even say, my belief, based on what we've now heard from the testimony of both witnesses that we had, was that it's not necessarily that they might have believed that they were in compliance with the rule without a second source test, but they believed very highly that they would no longer be above the emission limit for hexavalent chromium. And that's why they did that. So I'm not 100% sure, because Mr. Krishnadi said that he based his, or not he, or Montrose based their recommendation that just put in the filter and you're okay and you can start operating on the fact that that in cases where there's a new system, you don't have to have a source test right away. But he then on cross-examination said there is no similar exception for a source test after a failed source test. So I think it's a pretty unreasonable basis on which to say you don't need a passing source test. So I don't think it was reasonable to rely on that. But even if they did rely on it, and we went even as far out as December 11th, I want to look in our guidance, and our guidance for good cause says that petitioners who take days or weeks to conduct testing programs, attempt remedies, confer with vendors, consult experts, meet with attorneys, and so forth prior to the filing for a variance are not usually considered to be exercising diligence for purposes of determining good cause. So certainly I don't think it was reasonable to wait until a whole nother meeting on the 16th to determine with certainty that you need to have a second source test. You don't need certainty, just a reasonable belief that you need variance relief. And then to take it from December 11th to the 22nd, that's 11 days. That's a long time to get it together to file for a variance relief. And if it was that important that you have relief for another 3 weeks or so from today, then it would have been that important to come right in and ask for that emergency relief. And I don't see that urgency. So for those reasons, I'm having a very hard time finding a good cause. Other thoughts, board members?
Yes, I think I echo both your sentiments, finding good cause. On the other hand, I have to give credit to the facility in taking some of the actions, and when they knew there was a problem, ordering the HEPA filter and then shutting down when they knew the test failed. And then there's a section in the rule that says when you're failing measurement, the tank shall remain shut down until an acceptable measurement is measured. However, it doesn't excuse the fact that they should have of applying for a variance because they did not meet the emission limit that is in the rule and on the permit condition. So I think their misunderstanding or misreading or misinterpretation of the permit requirement and the rule requirement led them to where they are now today, even though they take the appropriate steps and were under the belief that by doing what they did and they should be okay. But that is, I think, hopefully they're aware now that that's an incorrect interpretation. So for that reason, I cannot find good cause because they did not know that.
Thank you. Ms. Verdugo-Peralta, you wanted to speak.
Thank you, Madam Chair. I think it's unfortunate that it's occurred in this manner. What I was also very concerned about, that there were assumptions that were made instead of actually looking at the rule, and including the footnotes, as well as if there was any doubt at all, whether it was on the side of Montrose or Coast Plating, that a simple phone call was not made. There was those assumptions that were made, and I'm looking at Montrose making those assumptions and then Coast Plating going right along with them. For those reasons, and the fact of the diligence and the time factors, which I also agree with our chair, were just too long. And again, if there was any question, they should have called AQMD and tried to get an answer on that. But they assumed that they were making the right decision. And that assumption is what, for me, is the core and the center of this problem. So for those reasons, I cannot find good cause either.
Thank you. Dr. Bernstein.
Madam Chair, all key element points have been made by my colleagues in their summations. The only difficulty that I'm having is that what is typical in this industry is quite probably over-reliance on your consultants. Your consultant is advising you one way, that is directing your thought process. And maybe Ms. Verdugo-Peralta has a point that you should have picked up the phone, but it seems to me that very typically these entities rely specifically on their consultants to give them that expertise going forward. And while I do look at the dates I'm conflicted with this simply because of the fact that you have an entity that is relying on your consultant to tell you one thing, and they believe that they address the problem from their knowledge with regards to replacing the HEPA filter, and that everything should then be in compliance and move forward accordingly, only to find out that that is in fact not the case. And in testimony, Mr. Krishnani was good enough to say that now, with hindsight, and hindsight is always 20/20, that he would have done it differently as well. But that is where my difficulty is with the case. I understand that the timeline that everyone has talked about, that apparently did take too much time, but in the same token, Coast Plating was being advised that to follow these particular footsteps and you'll be fine, right up until the point where it was obviously delineated, I believe on December 11th, that they would need a passing source test to proceed in full operations. And so I just needed to qualify that I'm conflicted with this because of that element that we've talked about with regards to consulting. Thank you.
Thank you. I think it's a very good point. Oh, go ahead, Senator. Why don't you?
Yeah, early on I asked whether or not there was an inspection report. And he said, yes, I know, but then he said, I didn't know if there was a written report. You see, in that report, they would have been informed what was wrong and given an idea how to fix the problem. Also asked questions about the mist eliminator. And they never gave me an answer about what they did to correct that or whether or not it was a real problem. And very well it can be a problem. So as they go and provide this source test today, it could be the mist eliminator could be a contributing factor as the cause of the problem. A report would have indicated that early on. If they had a report, they should have also given a copy to the district so they could be aware what the findings are. There are a lot of things they didn't know and understand what's going in their mind. That's why I asked whether or not Mr. Alonzo had a superior who knew or might have known what's going on with the system and what proposals they've used and entertained to resolve the problem. This is a systems problem. I know you give a flow diagram of a chemical, but it's the systems operation that fail or probably will fail if it's not together. So therefore you should know by now that that's a problem, has been a problem. And so therefore sorry to say, but I can't find good cause.
Thank you. I wanted to say something in response. I think that Dr. Bernstein, you make a good point that a lot of times there's a good reliance placed upon consultants to help you with things that maybe are not within your wheelhouse, et cetera. But I do think there needs to be reasonable reliance. And so I think when the two reasons that I think were most given today were, number one, lots of HEPA filters get replaced, and usually we don't have to let the district know. But there's a fundamental difference between once you have a failed source test and you simply think you know or assume you know what the fix is, you make the fix, but you haven't confirmed that that is actually the fix through a source test. So I don't think it's that's a reasonable basis, nor is the understanding that that in the apples to oranges comparison of when there is a new system put in place and there's a lag between that time and 90 days later when a source test is required, that they're allowed to go ahead and operate without a source test. That's different also, I think, fundamentally, than if there's a failed source test. And I just don't, I think there has to be a reason. We always have to count everyone who testifies before us as one entity, and Coast Plating has to take some responsibility for whether or not it's a reasonable reliance. And I think what Ms. Verdugo-Peralta was saying is perhaps it wasn't reasonable reliance. And so if there was still a question that remained, that should have been taken care of. But even after that, once they knew with certainty, I think 11 days is too long. I mean, this board knows we saw an entire a facility decimated by wildfire without knowing what had happened in that whole situation, and they were able to get in within a day to file a petition. And we look at that because usually if it's that much of an emergency, it doesn't take 11 days to file a petition, and it's not very diligent, I don't think. Mr. Balagopalan, you had more to add.
Just that I think they followed the rule as far as the reporting correctly. They reported the failed sources within 24 hours, and they took, but that's on the reporting side, and they did follow that, but it didn't give them they still did not meet the H4, which is the 0.001 file limit, which is what they needed the variance from. The reporting side, they did comply, and even though I think the district cited P4B Romanet 3 as the reason why they needed a variance, but I think Romanet 7 says if they're operating, if they're not in compliance, they just have to give an approximate date. On the reporting side, they were okay, but on the mission sides where they fail, and they should have taken the appropriate steps to file for a variance in a timely manner when they knew they didn't pass. I can see where they got the confusion, and the rule is, as Mr. Cohen said, is complicated, but nevertheless, there is a mission violation which they needed coverage for.
The emission.
That's all I had to add. Yeah.
And that's another issue I have, but that's with the substance. And so again, right now we're just looking to see should there have been notice to the public, and should we continue without that notice, which is so important, especially again, I didn't think actual emissions were relevant, but when you're dealing with something like hexavalent chromium, it's very important. It's always important to have public notice, but it's even more important to have notice to the public. So that's the backdrop of what we're looking at, not whether we would grant a variance. We didn't get to that stage. Ms. Verdugo-Peralta.
I just want to add one more thing. Having been a consultant myself, when a company hires another company to provide information, relevant information, especially in this case, it's a contributing factor. The company still has to make the decision. Whomever they select as their consultant, it is to provide information, but ultimately the company is responsible. And in this case, I think they relied too much on that consultant to give them the answer to the questions that they had. And they should have brought in the agency to also give them a contributing factor of an information that they would have been better able to respond to this. That's all I wanted to say.
Thank you. Any other thoughts before motion on good cause? Okay, I'll make the motion unless someone wants to. I'm going to make the motion that in the matter of Coast Plating Valence Surface Tech, case number 6201-1, that we dismiss without prejudice the request for emergency variance relief based on the fact that the board was unable to find that the petitioner acted with diligence in filing in a timely manner for a hearing. For a variance. Is there a second to that?
I'll second.
I'm gonna take Ms. Verdugo-Peralta raised her hand, so I'm gonna take her as the second. Is there any discussion on that motion? Okay, I'm gonna call for a vote then. Mr. Balagopalan, how do you vote?
Yes.
Senator Holden, how do you vote?
Aye.
Dr. Bernstein, how do you vote?
No.
Motion passes 4-1. And just to be very clear with what the decision is, the decision was without prejudice, which means the board could hear this matter for a variance if needed. With it, we have made no decision on the merits, just that we could not hear it without notice today. And at the sake of butting in on a business matter, I'm sure that Coast Plating would have a very good, especially if they paid for it, would have a very good argument for asking Montrose to expedite as quickly as possible the results of today's source test, since the source test is already occurring today, so that Coast Plating, if it passes, can get right back into business. Any other business, board members, before we do adjourn for today?
Is there a regular variance schedule on this, or short variance?
I think only the emergency was requested.
No, it wasn't scheduled because I mean, we're pretty convinced that we're going to pass. And so by the time the hearing would occur, I mean, we,
Oh, a short was requested, but it wasn't.
Oh,
scheduled.
sure.
yeah, we
Okay.
put it, but we didn't.
Apply for, okay.
Well, would you like to have one?
Yeah, I'd
scheduled?
like to set, can we get a date for a short variance?
Yes, and we're going to find out from the clerk right now what's the soonest we could have that hearing. Let's look at the calendar from the front. And Madam Clerk, that would be for a short variance.
Okay. Um, we, for the notice requirement, we're going to be into February. And we still have quite a few dry cleaner cases.
We would have to go into February for a posted notice.
That is correct. It requires a 10-day posted notice, and today is the January 7th. We can't get a notice out. Probably the newspaper can't publish until at least sometime next week. We're looking at either the 12th or after.
I'm sorry, posted notice requires the newspaper?
I'm sorry, even the posted notice, we can't post until at least Tuesday, which is the 12th. So even at January, but we have cases already scheduled.
Okay, so just so we understand, so if it were to go up the 12th, then
If it was to go to the 12th, the very earliest that we could have it would be January the 26th.
that's correct. Okay,
And we currently have an interpreter regular variance case scheduled for that day.
okay. And is that it?
That's the only thing that's scheduled on that day right now.
Okay, well, I think that with incorporating everything that from today's hearing, we probably could at least start the hearing and very likely finish it on the 26th if we can schedule it for that day. I know it's a lot. But I do think that given that, I think that they'll probably not need it past then. And I'm assuming that if you don't need it, you'll take it off calendar, correct?
Yes, sure.
What does the rest of our week look like? I'm sorry, Madam Clerk.
The rest of the week, we have a regular variance on the 27th, which is the Orange County Sanitation District. That's the only matter on that day. And then on the 28th, you have an interpreter, regular variance, dry cleaner case, and a status report on Ralph's Grocery Company on the 28th.
Well, definitely not the 28th.
No.
Yeah, those are all mine. Just chiming in. Sorry, I'll be here on the 27th and the 28th, the OCSD, and also the dry cleaner. But I am free on the 26th. Well, any day if you want to tack on a hearing, I can do. So I'm free.
So is the 26th the day that petitioner can be present?
I can certainly be present. Adam, would you be available on the 26th? 26th. You're on mute. Mute.
You said the 29th?
26th.
26th.
Madam Chair,
Yes, Senator.
is that a sufficient time to bring in the
Anytime. Well,
program manager in this case?
I'm not available for a short chunk of the day, but after 11, I should be fine.
Okay, sorry, I'm trying to hear what, Senator?
Good time for Mr. Cohen to notify the company to bring in the top level person on this issue.
I think it would behoove to do that so that all the questions could be answered.
Yeah, we can.
Yeah, I believe that he could be here. Unfortunately, again, as I said, he was out of town and in some meetings today and he couldn't.
Bring him next time. That'll be fine.
All right.
But let's set it. If there's an issue, I'll let you know. What else can I do?
Okay, or
For a hearing, they got to.
or Mr. Cohen, you can contact the clerk's office today, and the 26th, your more staff member can make it, then we'll do it then. If not, we'll wait till February, which is clearly more convenient for the board.
I couldn't hear you. Broke up. I'm sorry.
I'm sorry. Does somebody else have their? I'm just going to mute people really quickly. Okay. Should we set it? What I'd like to do is make sure that that person who has all of the information and would be able to answer all the questions as the senator was requested is available. So can you contact the clerk later today and let the clerk know whether the 26th will work for you? And if not, then we'll go forward with the original date in February. Oh, now you're muted. You have to,
Okay. Sorry.
What date in February?
I'm sorry. Did you hear the question?
No, I'm sorry.
Can you please contact, we won't set the date today, right, or right now. Can you contact the clerk's office later
Yes.
and find out if that person is able to make it to a hearing if we were to have it on the 26th? Sorry, is that the date? Yes, the 26th. And if so, we'll go forward on the 26th, and if not, we'll wait until that person is available.
All right. I understand.
All right. All right, so we won't set a date now, and Mr. Cohen will be in contact with the clerk's office today. Any other business board members before we adjourn for today? Okay, thank you all for
Thank you.
discussion. We are adjourned.
Have a good day, everybody.
Everybody. Bye.